Susie's got her a sound tech back there. All right, I guess we need to push our red button. So make sure our red button's on, or is it voice activate?
When the red light's on,
Red button's good.
it's working.
Okay. But the red button's got to be on, or it's not voice activated or nothing, right?
No, it is voice activated, and when you speak, the red light should come on.
Our red light's on all the time.
Well, but you're on your
Because I
microphone.
talk all the time.
Good morning, Donna.
Good morning.
Is that on?
Did the red light come on?
Red light's on.
Is the red light here on your microphone? Yes, then it's working. I see it.
Did you hear what I said?
I did.
Thank you. Now, it's on all the time. If I burp, it's going to, it's on?
You are to mute it if it's not to be on, but everything, of course, in the meetings are supposed to be on record, so.
All right, I think we all got our microphones figured out. Maybe.
One making it squeak.
I'm the one making it squeak. All right. All right, I'd like to call the meeting to order. Roll call, Ms. Hancock.
Marvin Alexander.
Here.
Bobby Colson.
Here.
Gary Cunningham.
Here.
Jeff Morris.
Here.
And Howard Phillips.
Here.
Mr. Chairman, you have a quorum.
All right. I see the first thing on the agenda is our formal hearing, so I guess I need to turn that over to Mr. Green.
Turn over to the
Administrative Law
Good morning.
Judge.
Yes, I'm Ann Johnson. I'm the administrative judge this morning. And where is Mr. Roebuck? Don't we want him up here? Good morning, Mr. Roebuck. There are few preliminary matters I need to go through, so if you'll bear with me, and then I'll give instructions as we go along.
Yeah, you may want to move that mic over closer to you.
This hearing is now in session. Today is March 4th, 2013. This hearing has been convened before the Tennessee Auctioneer Commission to consider the case of Kenneth N. Roebuck, docket number 12.15-117956A. As I've said, I'm Ann Johnson. I am an administrative law judge who's been assigned by the Secretary of State to preside over this matter. However, in that role, I will not participate in a decision on the merits since that decision will be made by the Commission. However, I will make all rulings of law, evidence, and procedure under the authority granted me by the Administrative Procedures Act. Now, I believe the Commission introduced themselves earlier for the record. Did you get that? Okay, good deal. And Mr. Chairman announced that there is a quorum present. Also present today is Mr. Mark Green, representing the state. The state is the petitioner in this case. The respondent, Mr. Roebuck, is also present. Mr. Roebuck, my assumption is you have no attorney representing you in this matter. Is that correct? And were you aware that you had the right to an attorney and chose to waive that right? That's perfectly fine. I would ask the attendees and the commission members if you would please place your cell phone on silent or turn it off so that our hearing will not be interrupted. Members of the commission are reminded that this hearing, it must comply with the Tennessee Sunshine Law, which requires that all board discussions and deliberations must be public and must take place before all parties to this proceeding. During the hearing, the commission sits as a jury and must consider only evidence introduced at the hearing and placed on the record. No commission members should discuss anything concerning this case with other commission members or anyone else except on the record during the hearing. Be especially careful during breaks and other recesses, since failure to comply with this requirement could result in a reversal if the case is appealed. Now I need to ask the board members if any of you have received any communications concerning this case or have other outside knowledge of the participants other than the notification of the hearing date. And did you have this, did you gain any information when all parties were not present? I realize you haven't seen the notice of hearing and charges yet, although you may have had other contact with this case. So after you receive the notice and see more what the case is about, if you don't already know, I would tell you that this is a continuing instruction, and I would ask now, have any of the board members had any such other knowledge or contact with the parties in this matter?
Your Honor, I'm Jeff Morris. I will recuse myself from any being involved in this proceeding. I've had a past history with this respondent, and will have no bearing on this case whatsoever.
Okay, all right, that's perfect.
I'll be sitting and listening, but I will not
Sure.
participate.
Okay, that's fine. Anyone else? Okay, thank you, sir. The petitioner will go first in presenting evidence in this matter. I would caution that, and then there will be witnesses. The petitioner will present witnesses. Mr. Roebuck will have a chance to ask those witnesses questions, and the board commission members will also have a chance to ask questions. I would caution you that any expression of opinion you may have regarding the facts or the witness testimony should be reserved until your deliberations. And if you have questions about that, let me know. Now I need to designate the technical record. This consists of the notice of hearing and charges, a procedural order from a previous administrative judge, the state's witness and exhibit list, the state's notice and affidavits, the state's second witness and exhibit list, an order of continuance dated September 27th, 2012, another procedural order dated October 11th, 2012, a second order of continuance entered October 18th, 2012, 9, the state's motion for continuance filed February 12th, 2013, and finally an order of continuance entered February 12th, 2013. Unless there are objections, additions, I'll enter these as the technical record. Mr. Roebuck, do you know what documents I'm referencing?
Yes, ma'am, I think so.
Okay. Now I'd like to swear in the witnesses. Do we have our witnesses here? Okay. If you plan to testify, will you please raise your right hand? Mr. Roebuck, I'm assuming you'll testify on your own behalf. Do you solemnly swear or affirm that the testimony you give in this hearing will be the complete truth? Thank you. Does either party wish to call for the rule?
I don't, Your Honor.
All right. Now, Mr. Roebuck, what this is, it's called the rule of sequestration. And it is a provision that requires all witnesses who are not testifying in the hearing at the time to leave the room. So the witnesses don't hear each other's testimony, in other words. Okay. All right. Neither party has called for the rule. I believe we're ready to publish the notice of hearing and charges.
Yes, Your Honor.
I've got. It'll take just a minute so that the commission members can read over that. And Mr. Chairman, please let me know when you're ready to proceed.
Everyone had a chance to. You ready, Mr. Phillips?
I'm ready.
All right, I should also,
Gary, you ready?
I'm sorry.
I'm
Are you
sorry.
ready?
Yeah, we're ready.
I also should add for the record that there is a second respondent in this matter, a business entity entitled Asset Recovery Auctions and Appraisals. It has a separate license number, and as I understand it, is also a respondent in this matter.
That's correct.
Okay. Mr. Roebuck, are you the sole owner of Asset Recovery Auctions and Appraisals?
Well, yes, ma'am. It ceased doing business in 09 or 010. or
Okay,
10.
but it wasn't incorporation or anything like that? Okay. All right, I believe we're ready for opening statements, and Mr. Roebuck, I'll give you a chance to make an opening statement after Mr. Green makes his, but don't feel like you have to. That's not a requirement, and it's not evidence that the commission will use in making their decision. Mr. Green?
Thank you, Your Honor. Mark K. Green, attorney for the Tennessee Department of Commerce and Insurance, and with me is Julie Kropp, attorney for the Tennessee Auctioneer Commission. This case is a consolidated matter of two separate complaints filed against Kenneth Roebuck, license number 2207, with the Tennessee Auctioneer Commission, and Asset Recovery Auctions and Appraisals, license number 3878. At all times relevant pertaining to the proof offered in this case, the respondent was licensed and did own asset recovery auctions. The notice of hearing and charges alleges violations of Tennessee Code Annotated 62-19-101 et sec, and specifically, but not limited to, 62. The Commission is authorized under Tennessee Code Annotated 62-19-120 and or revoke any license under this chapter for causes enumerated therein, and additionally, the assessment of civil penalties is authorized by that code under Section 56-1-3. Furthermore, Rule 0780-5-.11-.01, the Commission is authorized to assess investigatory costs and hearing costs. What the proof will show in this case, first, there was a complaint by Wanda Williams and Robert Braswell on September the 19th, 2009. Respondent conducted an auction for complainants Wanda Williams and Robert Braswell, who owned Donaldson Furniture Outlet of Davidson County. The proceeds of that auction netted $2,940. The respondent did not turn over the proceeds of that auction. In May of 2011, notice was given of a suit in General Sessions Court of Shelby County against the respondent for the amount of money owed by Donaldson Furniture Outlet. Pursuant to Tennessee Code Annotated 62-19-116, that notice provided that the complainants were going to make a claim against the Tennessee Auctioneer Commission Education and Recovery Fund, as provided in that statute. On July the 19th, 2011, after the required number of days had passed, that being 60, as set forth in that statute, a final order was received by the Auctioneer Commission with a court order directing the Commission to pay $2,940 to the attorney for the complainants due to the acts of the respondent not paying the complainants' auction. The Commission on August the 1st, 2011 voted at its regular meeting to approve the payment of the amount to the complainant's attorney as directed by the court, and to do so uncontested. On February the 2nd, 2012, a payment from the Tennessee Department of Commerce and Insurance was submitted in that amount to the attorney for the complainants. Under the provisions of Tennessee Code Annotated 62-19-116 regarding payment made by the education, all rights of the complainants are thereby subjugated to the Commission to collect the fees and expenses paid due to the claim against a licensee. On May the 3rd, 2010, respondent was indicted by the grand jury of Gibson County for 3 counts of felony theft up to $60,000. Respondent had contracted to hold an auction on behalf of the West Tennessee Judicial Violent Crime and Drug Task Force, the City of Trenton Police Department, and the Gibson County Sheriff's Department, all in Tennessee. The total amount of proceeds from that sale were approximately $52,620. Respondent did not account for those funds to the complainants after that auction. On October the 12th, 2010, respondent entered into a guilty plea for 1 count of theft and agreement of restitution. In turn, the guilty plea was entered under the judicial diversion statute, allowing the respondent's record to be expunged after service of probation and full restitution to the complainants. The proof will show that during this period of time, the respondent did act in a manner that harmed 4 victims: Donaldson Furniture Outlet, the West Tennessee Judicial Drug Task Force, the City of Trenton, the Sheriff's Department of Gibson County. And to each of these victims violated Tennessee Code Annotated 62-19-112, subsection B, paragraphs 1, 2, 4, 7, and 12. In addition, the respondent harmed the state of Tennessee under 62-19-116, subsection G, by causing a claim to be made against the Education and Recovery Fund, which is a separate violation. And finally, the respondent's conduct violates Tennessee Code Annotated 62 20-19-112, subsection 7, conviction in competent jurisdiction involving moral turpitude. Thank you.
Thank you, Mr. Green. Now, Mr. Roebuck, if you'd like to make an opening statement now, okay, that's fine. And you can reserve it until your proof if you'd rather, but again, it's not mandatory. Mr. Green, I believe we're ready for your witnesses.
Questions? Do we need to just wait?
If you wouldn't mind just waiting until the end, because those questions may be answered unless this is a,
No,
if you have a legal question.
No, it was just a time frame thing.
Oh, okay, all right.
But it can wait. I think it's all in order on here anyway. So
Okay. If you have any legal questions, you're welcome to ask me.
Yeah.
Okay.
No, this was just a time frame thing.
Okay.
It's good.
Your Honor, the first exhibit, before I call my first witness, I'd like to introduce for the court's consideration and the commission's consideration an affidavit of Robert Braswell.
Now, Mr. Roebuck, if you have any objection to the introduction of these into evidence, be sure and tell me.
I'll go ahead and introduce with that another affidavit of Wanda Williams. And my first witness will be ask her some questions about these affidavits.
Yes. Okay. Yes, that's granted. We've marked the affidavit of Mr. Braswell as Exhibit 1 and the affidavit of Ms. Williams as Exhibit 2.
I will call Donna Hancock. Ms. Hancock, will you state your name, please?
Donna Hancock.
And what is your position with the Department of Commerce and Insurance?
I'm the Executive Director for the Tennessee Auctioneer Commission.
And in that position, are you the, does your office, do you keep the records of complaints that come in on licensees?
Yes, we do.
And in your, first of all, are you familiar with the respondent, Mr. Roebuck? Are you familiar with his case?
I'm familiar with the case, yes.
And you have a file on Mr. Roebuck, is that correct?
That's correct.
And can you tell what that complaint file number is for the first complaint that came in?
First complaint was complaint number 200902515.
And that came in, you have a date that came into your office?
Yes, it was received November the 25th of 2009.
And who are the complainants?
The complainant is Robert H. Braswell. And, sorry. Trying to find the original complaint. Well, Robert H. Braswell was the complainant for that case.
Okay. And who was the complaint on?
It was against Kenneth Roebuck Asset Recovery.
Okay. And do you have Mr. Roebuck's license number?
I do.
What is that?
His auctioneer license number is 2207.
And do you have asset recovery auctions and appraisals license number?
I do. That number is 3878.
And when was Mr. Roebuck first licensed as an auctioneer?
His license was first issued July the 20th of 1988.
And is he currently licensed?
He is, with the expiration date currently showing of October 25th of 2014.
Okay. And does he, is he shown as the owner?
Is?
It currently licensed?
No, it is not.
When did it expire?
That license expired July 31st of 2009.
Okay. Go back to the complaint from Robert Braswell. What was the nature of that complaint?
The complainant alleged that a truckload of furniture was sold at an auction by the respondent and that the respondent had not paid the complainant yet for the sale.
And is that all the information on that?
That's all on the top of my notes, yes.
Okay, all right. So that's what your
That's
complaint.
the gist of the complaint.
Okay. Do you have a copy of the two affidavits that were just passed out? I'm gonna read the body of that affidavit.
Yes, it says, I, Robert Braswell, state that on September the 7th of 2009, a truckload of furniture was shipped to Asset Recovery and Auctions, Inc. in Memphis, Tennessee, to auction on September the 19th of 2009. Wanda Williams attended the auction and watched the shipment sail. Ken Roebuck has failed to send either a statement or a check. I have called him numerous times, to which he responded, I will check on it. In our last telephone conversation, Ken Roebuck told me that he did not have any money. Ken Roebuck owes me $2,900 for the items auctioned on September 19th, 2010.
And does that match the records of your complaint file?
Yes,
as to
it does.
The nature of the complaint?
Yes.
Okay. Mr. Roebuck ever notified when this complaint was entered by the office?
Yes, he was.
And did he respond?
I do not have a copy of that response, no.
Does that mean he didn't respond? Would you normally have a copy of
Yes,
that response?
I would. There is no response in the complaint file.
Honor, I would like to
Mr. Roebuck, any objection? We'll mark this as Exhibit 3. You may distribute to the board.
I have a law question. On this part of this complaint right here, the Braswell and Williams,
Uh-huh.
I do remember something about this because they called me, and I told them, only thing I know from them to do is file a complaint. And then I never found out what happened or anything, because I do know these two people. So, I don't know, as far as this part of this goes. Now, this other stuff I don't know nothing about. But this right here, I did have a little knowledge of. I didn't realize it till I saw the names.
Right. Well, thank you for disclosing that on the record. Do you feel that this prior information that you had would prevent you from being impartial and objective in making a decision today?
No.
All right. So any request for him to recuse himself?
None from the state, Your Honor.
All right. Then whether you recuse yourself or not is up to you. If you can be fair and impartial, then...
I feel like I can be impartial because all they did was told me they'd sent some stuff to get sold by Mr. Roebuck and hadn't got their money, and I said, the only thing I know to tell you to do is file a complaint. And
Okay.
that was pretty much it. And I never even knew that they'd got money from the recovery fund or anything.
Okay. Thank you.
Does everyone have a copy? Did she pass out the copy of Exhibit 3? Is that... All right. Have a copy of that, Ms.
No.
Letter. Can you identify that letter, who it's from?
The letter is from Attorney Paul N. Royal,
What is the date of that?
May 26, 2011.
And who is the letter addressed?
It's addressed to me.
Okay. And can you state what requesting?
The letter states that the attorney represents Robert Braswell, doing business as Donaldson Auction Outlet, and according to his conversation with you, Mark Green, he's writing to advise that on behalf of his client, he has filed a suit to obtain a judgment against the Auctioneer Asset and Recovery Fund in the amount of $2,900.
And is there a warrant or civil warrant attached to that?
There is.
And what's the amount? What county is that from?
From Shelby County.
And the amount of that civil warrant?
The total due is $3,084.50. And the judgment was for $2,940.
Okay. Thank you. Your Honor, without objection, I would like to submit this as in the record as the next. Show you another letter. Identify that letter, please.
This letter is also addressed to me from Paul Royal, attorney for Mr. Braswell,
What is the date of that letter?
July 19th, 2011.
And can you identify the purpose of that letter?
Says that, as in reference to my May 26, 2011 letter, I hereby respectfully request that a total judgment of $3,079.50 as to asset recovery auctions be satisfied from the funds on hand in the Tennessee Auction Education and Recovery Fund.
And is there an order from a court attached to that?
There is.
And what's the title of that order?
It's directing payment of judgment from the Auctioneer Education and Recovery Fund in the amount of $2,940.
And is that, what court is that order?
That is from the General Sessions Court of Shelby County.
I know that's a copy, but is it signed?
It is signed by Judge John Donnell.
Your Honor, I'd like to pass that letter and offer that as the state's next exhibit.
All right. That'll be marked as Exhibit 4.
Hancock, in your position as as the executive director of the Auctioneer Commission, do you receive financial documents and things of that nature regarding
Yes.
money that is spent on behalf of the Auctioneer Commission?
Yes, we do.
Before I go or show anything further, are you aware of the commission made apprised of the order of the court from Shelby County in this matter, ordering the Auctioneer and Recovery Fund, the Education and Recovery Fund, to pay the $2,940?
Yes, the commission was apprised of that during one of their monthly meetings.
And did they approve?
Yes, they did.
I'm going to show you an expenditure statement. That's an expenditure statement, and attached to that is a document. Can you identify those?
Yes, the first one is an expenditure report for the month of February, showing that, well, it says February expenditures. It was printed March 30th because they run late, but it does show that a total of $2,940 was paid out of that account on February the 6th of 2012 for a third-party expense distribution to Crispin Phillips and Associates.
And the second page, that is?
That's an Edison report, which is a computer system with the state showing that $2,940 was paid out of the Education and Recovery account.
Is there a case number? I know it's written, it's kind of small, but is there a case number on that document?
It says invoice case number 2009-02515, which is the complaint number.
Double checking your records, is that the complaint against Mr. Roebuck in this matter?
It is.
Okay. Your Honor, I would move to enter those documents as collective exhibit number 5.
I'll need a copy.
Sorry.
Without objection, that request is granted and will be marked Exhibit 5. Thank you.
Hancock, was there another case that was opened against Mr. Roebuck?
Yes, there was.
When was that open?
I have the complaint number on that one. I don't have that file in front of me.
Okay. What is the complaint number?
The complaint number is 20120289.
And the reason you don't have that, can you explain, was that, where did that go when that complaint was opened?
It went to our legal department.
Your understanding what was going to happen to the complaint?
That the two complaints would be combined.
Okay. And do you know the nature of that complaint, that second complaint, what generated that?
Yes, I have a printout, a report showing that there was an allegation of fraud for failing to remit monies owed.
Okay. That's all I have of Ms. Hancock, Your Honor.
Board members, questions for this witness? Right. Thank you, Ms. Hancock. You may step down.
I apologize. I'll call David McGriff.
Mr. McGriff, you were previously sworn in, is that correct?
Yes, ma'am.
Okay, thank you.
Sir, will you state your name, please?
David McGriff, M-C-G-R-I-F-F.
What is your title?
I'm the Chief Criminal Investigator with the District Attorney's Office in Memphis, and as such, I direct the West Tennessee Drug Task Force.
How long have you been doing that?
Too long sometimes, I think, but 36 years.
Okay. And are you familiar with Mr. Roebuck?
I am, sir.
How did you become familiar?
Mr. Roebuck has conducted a number of auctions for the West Tennessee Drug Task Force in Shelby County.
Ballpark?
Oh, probably 7 or 8 that I can remember.
And over how long a period of time?
10 to 12 years.
Never had any problems?
No, sir.
Were you the contact person with the DA's office with Mr. Roebuck?
Yes, sir.
Okay. And did you hire Mr. Roebuck?
I did.
And when was that? Do you?
That was November the 8th, 2010. I'm sorry, the actual auction date was November the 8th, 2008.
Okay. So you hired him before that?
Yes, sir.
Okay.
To conduct an auction on the 8th day of November in Milan, Tennessee.
And what was the auctioning?
It was for the sale, public auction of seized vehicles that had been seized by the West Tennessee Drug Task Force and forfeited pursuant to state law by the Department of Safety.
And did you coordinate for any other agencies?
I did, sir.
And who was that?
That was the Sheriff's Office of Gibson County, as well as the City of Trenton Police Department.
Did you enter into a contract with Mr. Roebuck?
I did, sir.
And was that was on behalf of Shelby County?
That's correct.
Did he conduct an auction in November of 2008?
Did, sir.
And total proceeds, do you know how much the proceeds of that auction were?
I do. The revenue of the sale of vehicles that day for the 3 combined agencies was $52,620.
That's all 3 together?
Yes, sir.
And what was the terms? What were you payment?
Shortly after the sale, after Mr. Roebuck was able to collect the funds, and I believe it was within 10 days.
Okay. Did you collect the funds? Or
No,
did
sir.
you receive the funds?
No, sir.
And why?
A number of telephone calls were made to Mr. Roebuck, as well as a number of letters were prepared and submitted to him. I personally spoke with him. He indicated that he had had some severe financial problems and was unable to make payment and was requesting some additional time. He was given some time. However, he was advised that at the end of that time that he was allotted, he'd have to make payment in full, or the case would be submitted to the District Attorney's Office in Gibson County, Tennessee, for criminal review.
Who was your boss at the DA's office?
At that time, my boss was William L. Gibbons, the District Attorney for Memphis, Shelby County.
And did you have conversations with General Gibbons?
I did.
Okay, so you were assuming, being asked by your superiors, hey, what's going on with the money?
Manner of speaking.
Okay, all right. And you had contact with Mr. Roebuck during that time?
Yes, sir.
Ever get paid?
No,
Or
No,
in
sir.
that period of time, before any criminal review was had taken place?
no, sir.
Okay. What happened after At what point did the DA's office decide to do something else?
Well, I prepared a letter to the District Attorney, Gary Brown, of the 28th Judicial District in Trenton, Tennessee, who, by the way, is a member of the Board of Directors of the West Tennessee Drug Task Force, setting out the facts and circumstances of the auction, copies of the letters that had been sent to Mr. Roebuck, and that and we had not been paid, and requested that he review the case for criminal prosecution. As a result of that, indictments were drawn up and presented to the Gibson County grand jury. 3-count indictment for theft over $60,000, 1 count and 2 counts of theft over $10,000, which would encompass the 3 agencies that were involved that had not been paid. And as a result, the grand jury returned a true bill of indictment on May the 3rd, 2010.
I'm going to show you a document and ask you if you could confirm this.
Yes, sir. This is
That's a copy of the grand jury indictment.
Yes, sir.
Your Honor, I would move to enter this as the next state's exhibit, I believe Exhibit 6.
Hearing no objection, I'll mark it as Exhibit 6. Mr. Green, I noticed this isn't signed.
It isn't, Your Honor. We could not get a copy because of there were judicial legal reasons we could not get a signed copy. That copy came from the DA's office, from Mr. McGriff's office.
Okay. But Mr. McGriff has said that this is a copy of what was handed down.
Exactly.
Not a proposed indictment, but...
That is what was handed. Mr. McGriff, was that what was handed down?
That depicts a true and accurate copy of the indictments that were submitted to the Gibson County grand jury, of which they, in fact, returned true bills.
Thank you.
If I assume this went to court at some point. Is that correct?
It did, sir.
And was there, were you involved in any of the negotiations, or
I was not.
have knowledge as to what was the... Before I go there, let me back up a little bit. You had testified that you coordinated between Trenton Police Department and Gibson County Sheriff's Department. Is that correct?
Correct.
They were owed money separate from what the West Tennessee Judicial Drug Task Force was owed.
That's correct.
Did they get satisfied as far as payment before you did?
They did, sir.
And how did that happen?
Mr. Roebuck submitted a cash payment during the time that he was going to court, or just before, and a decision was made to disperse those funds to the 2 agencies that had entered into the auction, and that would have been the Sheriff's Office of Gibson County and the Trenton Police Department.
Okay, so there was a amount paid, and then you decide your office went ahead and paid Trenton and Gibson County.
To be quite honest with you, we felt an obligation to pay the 2 agencies that we had extended an offer to come to the auction, and to pay them first, and that's what we did.
Okay. All right. Is there a settlement involving the criminal charges, Mr. Roebuck?
There was, sir.
I'm going to show you a judgment sheet that is signed. You identify that document?
Yes, sir. This is a judgment sheet in the Criminal Circuit Court of Gibson County, Tennessee.
What does that judgment sheet indicate was the judicial resolution of Mr. Roebuck's case?
This was a guilty plea to theft of property, $10,000 to $60,000. And this, by the way, was on October the 12th, 2010. And as a result of this guilty plea, there was negotiations and an agreement for Mr. Roebuck to be placed on probation and diversion of the sentence upon completion of the payment of the funds that he owed the West Tennessee Drug Task Force.
Okay. There was initially 3 charges. There was indictment on 3 counts, correct?
Sure.
2 of them were dropped.
2 of them were dismissed, and Mr. Roebuck entered a guilty plea to the 3rd one.
Okay. After part of the guilty plea was to enter under the judicial diversion statute, which required him to do certain things. Is that correct?
Restitution of the funds that he owed the West Tennessee Drug Task Force.
Okay. And was that over a period of time, or was that?
Yes, sir.
Yep.
Given an opportunity over a period of time to make payments to make full restitution of the amount that he owed.
Okay. And legal, in your understanding of it, did that mean he stayed out of jail as long as he was doing what he was supposed to do?
Well, I can't speak for the judge, Mr. Green, but I mean, he was on probation, and he was, part of his probation was to make the payments to make restitution.
Okay, all right. So that was part of his sentencing, that he was given the opportunity to do that?
Yes, sir.
Okay. And as the point of contact for the judicial district, and before I do that, Julie, would you pass these? I'll move to enter these into the next state's exhibit.
I notice there is a Social Security number on this document. Since this becomes a public document, we need to...
I will get it redacted.
Okay. All right.
I'll get it redacted real quick.
Okay. Okay. Then we'll...
Pass those out.
Thank you very much.
Does that?
Yes, I think that'll be fine. Thank you. We'll mark this as Exhibit 7, and you may pass it out to the Commission.
About another.
Yes.
Has hearing of that judgment, what What has been his payment history to your office?
Mr. Roebuck currently is up to date on his payments up through March the 1st, so his next payment will be at sometime in March. And if I may read the amounts that we started and what we're standing with right now. We started with the amount of $38,715. Mr. Roebuck committed a payment of $20,000 to that $38,000 shortly after the court proceedings. And he's down to $13,822 as of December the 12th, 2012. His next payment will be March the 12th.
So he's paying. He's paying as ordered.
Yes, sir.
Paid one, I guess, after the nation in his made one very large payment. Is that right?
He did, sir.
And I guess before that we.
Right.
Since then, he has continued to pay, and he owes back $13,000 some.
$13,822.06.
Your Honor, that's all I have of Mr. McGriff. I'll pass the witness.
Mr. Roebuck, do you have any questions you'd like to ask Mr. McGriff?
No, ma'am.
Commission members, do you have questions for Mr. McGriff?
So the way, Mr. McGriff, the way I understand it, all these sales were on one day,
Yes, sir.
and then y'all kind of got the, let me get my, Trenton and Gibson County to come in with you on the sale, and then when some first payment was made, y'all went ahead and paid Trenton and Gibson County back, and then kind of took a hit yourself, a brunt of it, to take it upon yourself to recover the rest of the money.
That's correct, sir.
Thank you. Anybody else?
How many auctions had he done for the sheriff's department?
Well, actually, Mr. Roebuck had done many auctions for the Shelby County government. We weren't necessarily involved in each one of those. But we participated through Shelby County government with their auctions, and Mr. Roebuck at least 8, maybe 10.
Had there ever been a problem of payment?
Never ever been a problem.
Was it a contract type deal, like a year contract, 5-year contract, 2-year contract, or an individual type deal with each sale?
Mr. Roebuck had a contract with Shelby County government. And it was, I'm not sure what the number of years were, but it wasn't a...
It wasn't an individual basis each time?
No, sir.
Okay. Anybody else have any questions for this witness?
Thank you, sir. Oh, did you have another question, redirect?
No, Your Honor.
Okay.
Your Honor, that closes the state's proof.
Mr. Roebuck, anything you'd like to say?
I'll stand here or get up.
Can you all see him there? Could you see him better if he came up here?
Your Honor and gentlemen, I come before you this morning not to deny any of this, other than the fact that when Asset Recovery ceased doing business, I had full understanding that every one of my consignors had been paid, with the exception of the Drug Task Force. I knew nothing of the lawsuit that was filed on behalf of the Braswells. I thought they had been taken care of when like I said, I thought I had over 200 consignors. I thought every one of them had been paid for. They slipped through the crack. How, I do not know. But I've been in this business almost 28 or 29 years. I've never had any complaints against me at all. The time period of 2007 and 2010 is a period in my life that I wish on nobody. I lost a 27-year marriage. I lost my business. I lost my home. I have nothing. I live with my sister at the time, present. I'm in the process of rebuilding a life. I am complying with the court order. I have never had any other convictions or arrest of any sort. I've only had 2 or 3 speeding tickets my whole life. I'm not a criminal. I'm just an unfortunate person that had things go wrong. The only thing that I would ask and plead to the commission is some leniency and some sympathy. Any monetary, without my license, I have no way of making any money to pay back whatever you decide is civil penalties or continue to pay on my diversion. I've done well in taking care of that and trying to meet my obligations. And I apologize to my profession for what has happened with me and the things I had no control over. Other than that, ma'am and sirs, I suppose that's all I've got to say.
Thank you, Mr. Roebuck. Mr. Green, do you have any questions you'd like to ask Mr. Roebuck?
Just a couple questions. Mr. Roebuck, are you currently doing auctions right now?
When I can get one, or I work for my dad sometimes.
Okay, so you don't own the business, right?
No, sir. I just do contract auctioning.
Okay. And you had no other source?
No, sir.
That's all I have, Your Honor.
Commission member, questions from...
I have one question. I understood that asset recovery license was given up or not renewed as November 25th, 2009. Is that right?
Somewhere like that, I think. And it may have, Mr. Marvin may have expired, and I had not known it at the time.
Did you put your firm license with after that?
Southeast Auction Group.
What is throwing me?
Well, excuse me, I moved it to John, Roebuck Auctions.
Every auctioneer has to be under a firm.
Right, it's Roebuck Auction.
I don't understand why that firm license is not involved with this case.
Roebuck Auction?
You had to be under a firm when you operate.
Well, at the time, it was Asset Recovery and Appraisal. That was a firm license.
This auction happened after 2000, didn't it?
No, sir. I think it was prior.
The auction of the...
I think that was right about the same time as in 2009.
September of 2009.
Roebuck, how many people did you have in asset recovery?
Just myself, sir.
Who handled the accounts payable? Who handled the accounts receivable? And you didn't know there was a problem?
Yes, sir. It was a very struggling time for me.
Did you have a CPA?
No, sir.
And you signed the checks? Okay.
Mr. Roebuck, I assume that you had a auction account.
Yes, sir. There was a separate escrow account.
An escrow account. And after every auction, did you put all your money into the
Yes,
escrow account? How did you slip up one time and not pay 2 people?
Can't answer that question. It just happened. I mean, like I said, that was at that point in my life, I was losing everything. Everything was crashing around me. I mean, severe depression. I lived in a warehouse for 3 years. I lost my home. I lost my wife. I lost my family. I lost my business. I lost everything, sir. To this day, I have not. I don't have anything.
And I have sympathy for you, because I understand that people have hard times, and they sometimes it's beyond their means, but I do not understand. I can't get in my head how you could sell the sheriff's department merchandise and then sell the furniture and put it in an escrow account and not write those people a check, and you didn't know that it wasn't paid.
The drug task force, I knew that the funds were not there to pay that. I'm not questioning that at all. The other, I absolutely knew, I thought that it had been taken care of. Like I said, I had over 200 consigners through that auction, and I was under the impression that every one of them had been taken care of, with the exception of that. I knew nothing of the lawsuit. I knew nothing of the going through the court and getting a judgment against me. I knew nothing of that. I never had any type of mail or anything. Like I said, now I was in a world of hurt at that time, so I may have gotten mail at an address that I was no longer at. But I was trying to save a struggling business, and it was taking auction to take care of the last one. It was my fault. At that time, the economy was collapsing, merchandise was unavailable, and it was just going down, down, down. And instead of being smart enough to stop it when I should have, I tried to save it and tried to hang on to it.
I don't have any more questions.
I have another question. Mr. Roebuck, did you, when you filed federal taxes, tax returns, did you claim that as income?
Did I claim it as income? No, sir.
So did you file federal income tax?
Yes, sir.
Well, if you took in the money, how did you get around not having to either claim it as a loss or as a profit?
Sure, it was claimed as a loss.
And you handled your own taxes, did you?
No, sir. At that time, I can't remember exactly when I was unable to stop affording a CPA. At one time, I had I think his name was Larry Jackson that was handling it. I really cannot remember at that time.
Anybody else have any questions? Marvin, you look studious over there. Have you think of anything else? Okay. Where do we go from here?
Mr. Roebuck, do you have anything else you want to say? And if you want to make a closing statement, I'll let you do that later.
Other than the fact that I would just appeal to, as far as the concern of the license go, is if the monetary penalties that you assess on me, I'll agree to pay it if there's any way I can keep my license. But without the license, there's no way that I can tell you right now I have no money, and there's no way for me to generate any money without that license. I think my past speaks for itself as far as 20 some odd years with no complaints, and no complaints since these. Like I said, my life is getting back on track, and I'm taking care of my responsibilities, and I just would ask that, I'll accept whatever civil penalties you agree to, and, as long as they can be paid out over time. But without the license, I can tell you right now that I won't be able to pay it. At 52 years old in this economy, there's not a great big job market for somebody that has no other skills other than auctioning. But if you'll allow me the opportunity to keep my license, then I'll promise you this: you won't have any more complaints, and I'll take care of my financial responsibilities.
Mr. Green?
Your Honor, I will try to wrap this up briefly. In the notice of charges and notice of hearing and charges, the alleged conclusions of law, the state would offer that under subsection 1, as regard to the West Tennessee Judicial Task Force, the state would argue that it has proven the respondent did violate 62-19-114, Section B. I'm sorry, that should be 1112, Section B, 4. The Commission has the authority to revoke, refuse, renew any license under this chapter for any of the following causes. Subsection 1, making any substantial misrepresentation. Section 2, pursuing a continued flagrant course of misrepresentation. Section 4, failing to account for or remit within a reasonable time any money belonging to others that comes into the licensee's possession. And Section 12, any conduct of any auctioneer which demonstrates improper, fraudulent, incompetent, or dishonest dealings. As regard to the complaint regarding the West Tennessee Judicial Task Force, Drug Task Force, the state would argue that that has been proven, as well as separately to the City of Trenton Police Department. The state would argue under Section 2 that, or Paragraph 2, that those same elements have been proven, and under Section 3, as it regards to the Gibson County Sheriff's Department, that those allegations have been proven. Under Paragraph 4, the allegations as to the charge above involving Wanda Williams and Robert Braswell, the state would argue that the same codes listed as above have been proven, and additionally, a separate course of action under Paragraph 6, 62-19-116G, where the Commission has paid out of the Auction and Education Recovery Fund on behalf of a licensee to an injured complainant. Under Paragraph 5, immediately above, the state would argue that under 62-19-112B6, the Commission may deny, revoke, or suspend the license of any licensee convicted in a court of competent jurisdiction, this or any other state of criminal offense involving moral turpitude or felony. The question that I believe the Commission, Mr. Roebuck entered a judicial diversion guilty plea. The state would argue that that's a guilty plea. However, upon the terms of him meeting the terms of that plea, it may be expunged. Nonetheless, in the interim, it is a guilty plea that can be considered by the Auctioneer Commission. The above violations that are alleged by the state, the Auctioneer Commission has the authority to seek or to assess civil penalties for $1,000 each, and including in the penalties the reimbursement of $2,940 to the Tennessee Auctioneer Commission. The state is also seeking all hearing and investigatory costs and revocation of the respondent's auctioneer license. Thank you.
Thank you. The Board has heard proof in the matter presently under consideration. It is now my duty to charge you as to the law you must follow in reaching your decision. You are the exclusive judges of the facts in this case and also the exclusive judges of the application of your rules and statutes. You must base your determination solely upon the evidence and legal arguments presented to you during this hearing. The evidence consists of testimony given by witnesses and exhibits introduced into the record. The state has the burden of proof by a preponderance of the evidence to show that the violations alleged were actually committed. Statements made by counsel during the course of these proceedings are not to be considered as evidence, but as argument to convince you of their respective positions. Similarly, you should not infer from any of my rulings or instructions that I hold any view or opinion for or against any party. Now, Mr. Green, my assumption is we have no proposed order, or you do?
Your Honor, I was going to use the law as it was on the notice of hearing.
Okay. Mr. Green, the state has referred to the notice of hearing and charges. If you wish, you may use this as a guide in conducting your deliberations. However, you need to consider each fact and each violation separately and ensure that it was proven and proven on the record. The Administrative Procedures Act requires your order to contain four parts: findings of fact, conclusions of law, disciplinary action, penalty, that type of thing, and number 4, a policy reason for your decision. In determining findings of fact, you must make your own evaluation of the testimony given by each of the witnesses and give that testimony the weight and credibility which you believe to be warranted. You may weigh the evidence in light of your own training and expertise. Once you have made findings of fact, you must decide whether the petitioner has violated any provision with which, whether the respondent has violated any provision with which he has been charged. You must confine your deliberations to the violations listed in the notice of charges. Then you need to formulate conclusions of law, which consists of the statutory and regulatory provisions as cited in the notice of charges. Of course, you must decide whether these are applicable in this case. Your decision should include sufficient analysis of the evidence to clearly demonstrate how the facts show that a certain violation was committed, if you find one. And then any disciplinary action, Mr. Green has outlined those for you, and they are stated in the notice of hearing and charges as requested by the state. Of course, you use your own judgment in deciding whether or not to go along with the state's recommendation, and it is just a recommendation, or whether to substitute or not to impose a penalty. Then, finally, you must formulate a policy reason for your decision. That simply tells why you believe the action you've taken is appropriate in this case. Your deliberations must be in public before all parties. Counsel and the parties do not participate in the deliberations, and I will also not participate. However, if you need assistance with the law or the structure of your order, I will be available to help you. If you have any questions about the facts presented, you may, by a majority vote, reopen the proof and hear from witnesses to refresh your memory. Unless there are questions concerning my charge, I will now turn the hearing over to the board chair to conduct your deliberations.
All right. And I may need some guidance here as far as how to start this, but from what you said, I guess the first thing we need to do is see if we have a finding of fact to see that the state proved their case.
Right, and you would need to find all of the facts that you believe are relevant and proven,
Right.
as shown in the testimony and evidence today. And as I said, it sometimes is helpful to use the notice of hearing and charges starting with the allegations of fact.
Right.
But then I would ask that you discuss those separately. And then at the end, it's sometimes helpful to take a roll call vote when you get all of the facts.
Right.
Okay.
Well, as far as what the state presented to us, this is allegations of fact or finding of fact is, the first one was the Violent Crime and Drug Task Force, $38,715, which from witness testimony was along with the City of Trenton and Gibson County, which is another $9,305 and another $4,600. And I don't say that any of it was denied or anything like that. And then you got the separate one for the $3,000. And so I guess would that fall under the, or this may be the other part of it we get to later, the 6219, 112, the misrepresentation and all that stuff that's on the front. No, that's our authority to do it. So
Right.
I'm heading in the right direction with my allegations of fact, right?
Exactly, yes.
Okay. And I guess we need to take them one at a time as far as the state proving or Mr. Roebuck. Side or we'll entertain any suggestions for finding of fact.
It appears to me that the state has proved its case, and the witnesses that have testified, we have the exhibits showing when they were filed and that they were presented, that there was an agreement made for him to conduct the auction, and the auction was held. Money was not paid in, and by his own admission, he's agreeing to that. There was no questions asked of any witnesses, which indicates to me that what the witnesses presented to us is the facts in the case of each one of these.
Do we need to do that on an individual basis with each one of these?
I think it would be good to put that on the record if you wanted to
Okay.
just read through number one, number two,
Okay.
and so forth, and see if that, each fact represents your own independent recollection of the evidence presented.
All right, well, go ahead.
I'll just say that was on the 38,750, the first.
For the violent crime and drug task force. Okay.
Let me stop you there. So are you accepting the first two?
No, actually, that was the first one from an order that I've got them in.
Looking on page 2,
Allegations
where
of
it
fact.
says allegation of fact,
Mhm.
the respondent is a licensed auctioneer located in Shelby County?
Yeah.
Okay.
And then the first one was, the first allegation was number 4, which was the violent crime drug task force, $38,715.
Right. But it might be helpful to go ahead and consider those background facts. In other words,
okay.
to show how you have jurisdiction to hear
Okay,
this.
okay, I understand now. Okay. Start with number 1 up there. This part of the allegations of fact is that the respondent is a licensed auctioneer located in Shelby, Tennessee.
Well, I would say that it was proven here that Mr. Roebuck did have a license number with the state, 2 licenses, one in his name and one in asset recovery. and that he was licensed. He was permitted to do business. It lists both of his licenses. His personal license was 2207, and the company license 3878. Number 3 says that he was indicted because he didn't remit the money, which we have the papers from the court that has been presented by one of the witnesses that substantiates that. And it also shows that he was charged with that in the Gibson County Court.
All right, now do we need to stop right there on that one before we get to the other two counties?
It's up to you. I do think it's good to discuss each one.
Okay.
And if you wanted to just take a voice, A or nay vote on accepting these as written, like numbers 1, 2, and 3, I think is what Mr. Alexander discussed.
Okay. All right, I guess everyone agrees that, or does everyone agree? That's what I'm asking. And was it discussed that, and I don't remember, I know it was because I made a note about it here, but I don't, these sales were conducted by Asset Recovery, and was it licensed at that time?
His firm license had expired in July 2009, and he conducted that sale in September 2009, so his firm license had expired at the time he conducted the auction.
No, sorry.
Okay. But that's not in the allegations of fact, so it doesn't really make any difference anyway, right?
Exactly. You
Okay.
can't penalize him for
Okay.
that because that's not one of the violations charged.
Okay, so we're back to the allegations of fact that had a lot of 1, 2, and 3, and do we vote on that, or does the members feel like that the state proved that the allegations of fact 1, 2, and 3 are true and correct, or?
Someone could make a motion, perhaps, and then you could say all in favor,
Okay.
say aye.
I would make that.
Second.
Okay, we have a motion by Commissioner Alexander that of allegations of facts that the state made 1, 2, and 3 were proven. All in favor? All opposed? All right. Would someone like to go down to number 4? Or we could read it all in, and if unless there's parts of it you want to take out or whatever. And
on number 4, there was the Sheriff's Department and somebody else added.
Yeah, they were added. They were added in 5 and 6. We could do 4, 5, and 6.
I think we should do them all together.
Okay. Would you like to make that motion?
I make a motion we include 4, 5, 6, and 7. Is that correct?
Let's just
6. 4, 5, and 6.
Yeah, let's just go 4, 5, and 6, because that gets into the money, and then the other ones contend with what happened after that. So we have a motion by Commissioner Phillips to agree that the state proved allegations of fact, or allegations of fact, finding of fact, or 4, 5, and 6. All in favor?
I'll second that.
Oh, seconded by, excuse me, by Commissioner Alexander. All in favor? All opposed? All right. Now, on to number 7. which I think spells out where the respondent pleaded guilty, and also brings in maybe 7, 8, and 9, and 10 to the, well, no, wait a minute, let's see here. Okay. Okay, number 7 probably should be by itself, because it deals with the 3 previous ones we just voted on.
Mr. Chairman, he said that he didn't object to these charges. He admitted that they were all correct. Is that not true?
Yes.
So could you not combine the rest of them?
Well, I think it might be a little cleaner if we're doing one at a time, or
It's up to you.
up to us. I'll tell you what, let's do.
You're the boss.
Let's do number 7, and then all the rest of it deals with that other one. So let's do about 2 more.
Okay.
Because like you said, there wasn't any of it denied or anything. Entertain a motion for number 7, that respondent entered a guilty plea and included a 2-year diversion of the judicial diversion statute of the state.
I believe that was proven by Mr. David McGriff. He testified.
Yeah.
That and brought in, we have a copy of the agreement here from the Criminal Circuit Court of Gibson County that this, that he did enter a guilty plea and accepted the 2 years diversion period and agreed to pay restitution. So I believe that finding of facts has been made.
Okay, do I have a second? We use that in the form of a
I'll
motion.
put that in the form of a motion.
Second.
Seconded by Commissioner Phillips. All in favor?
Aye.
Aye. All right, now jump in there, Howard.
Well,
Which would be 8 through 16.
Do you think that's what we want to do?
I think so. I think it'd be fine. But like the rest of it deals with the Dawson Furniture Company, and
Okay, I'll make a motion that we combine 8 through 16.
saying that the state is proving
Yes.
their
Prove fact.
allegations of fact, which we have a motion by Commissioner Phillips to approve or to accept as allegations of fact numbers 8 through 16. Do I hear a second?
second.
Second by Commissioner Cunningham. All in favor?
Aye.
Now we move on to conclusions of law. And the state is using 62-19-114B4, which is misrepresentation, false promises, failing to remit within a reasonable amount of time, monies belonging to others, commingled funds, which says, or failing to keep an escrow or trustee account. We really don't know about that. I think Mr. Roebuck said he had an escrow account, and I don't doubt that. And improper, fraudulent, or dishonest dealings.
Now, just
And
for the
then,
record, I'm sorry.
Yeah, no, go ahead. I was fixing to ask you.
Just for the record, I believe Mr. Green indicated that there is a typo in that alleged conclusions of law, that it should be 6219-112
112.
instead of 114.
Okay.
And I think it would be appropriate for you to consider each of those allegations and see if you believe that this conduct that you've already listed in your findings of fact shows that any of these was violated.
Okay. So it should be 62-19-112, which says suspend, revoke, or no, which says misrepresentation and all that. I got my laws right here, I reckon I'll look and see. Yep. Okay, so our first, am I allowed to ask, is who's taking minutes? Which I did as far as my first.
I think Mr. Green will be responsible for drafting the order.
Okay.
And so I will ask him at the end if he has any questions.
No,
about
I'm just,
what you
what
said.
I'm saying is, I've been making notes and scratching and drawing lines, and like I know we did the first three on the allegations of fact, but we need to come back and find a conclusion of law that meets that, right? Or see if this 62-19-112 was violated in that.
Right.
Right, okay.
And
I was
you'll
gonna-
notice how the notice of charges is written so that the facts are tied to the violations, and that is a requirement. If you say he violated this statute, then you need to say what conduct shows that he violated it.
Okay,
And so that's why I'm assuming that the state has divided these into, number one, has to do with the incident with the Judicial Drug Task Force.
okay. Oh, okay, I see now, okay. All right, so as far as our conclusions of law go, number one, was the West Tennessee Judicial Drug Task Force, and the state is concluding that they violated 62-19-112, and then you can read there what that states: substantial misrepresentation, flagrant course of misrepresentation, failing to remit money, any conduct of an auctioneer demonstrates improper, fraudulent, or incompetent dealings. So,
The way I understand what you're saying, Judge, is that we need to discuss just number one of that, right?
I think that would be most helpful, because this does a nice job of tying in what specific fact with what specific violation. So if you wanted to go through those that are listed there and decide, did the facts show that the respondent, one, made any substantial misrepresentation? And then,
okay.
But when we do this, each one of us need to just take the one, and each one of us make any comment about that, and then go to two, or can one person go through
that
the
might
list?
be more helpful, but however you want to do it.
As far as number one, I don't think there's any doubt that, I think the proof has been put on that there's been substantial misrepresentation, because when you enter into a contract, Mr. Roebuck had a contract with the drug task, or the city of Memphis, to conduct an auction, and when you enter into a contract, you agree to pay the proceeds for what you sell.
Or Shelby County, or whoever
Shelby
it was.
County. So I think that the misrepresentation started there and continued.
Okay, so
Nobody would enter into a contract with you if you weren't going to pay them.
So as our first conclusion of law, do we have a motion that says that 62-19-112 was violated? That was his motion. Do I hear a second?
Is that just on number one?
Yes. She said we need to take them one at a time.
I second.
Any further discussion? All in favor? On number two, is that supposed to be 62-19-112 also, Mr. Green?
Yes.
Oh, I'm sorry, Your Honor. Okay, and that deals with the Trenton Police Department.
Oh, now, wait a minute. So are you not finding that any of these additional sections of 114B were violated?
Oh, I thought it was changed out. I didn't know it was just omitted. 112, so the 114B needs to stay there.
No, the 112B, and then if you want to decide whether, you've already decided that he was guilty of making substantial misrepresentation. Now, did he in this action with the Drug Task Force pursue a continued and flagrant course of misrepresentation, promises through agents or advertising or otherwise?
Your Honor,
Okay.
on number 3, the allegations as to the auctioneer's charge, that paragraph there, then it says, section 62-19- it said 114. Is that supposed to be changed to 112, or is it supposed to be left as 114?
If you look in the Green Book, what is actually being quoted there is 112.
112, okay.
Yes.
All right. So we need to go ahead.
I changed mine.
So we need to go ahead down to,
We take them individually, but every one of these is under the same case.
right, but what,
I mean, under the same number,
Right,
62-19-1112.
right, but what she's saying is we need to, the judge is saying is we need to add to it the other thing, the B, 1, 2, 3, 4.
I'm not sure I understand the question.
I don't understand what you asked me.
Okay.
I thought we were going to go 1, 2, 4,
4,
and
12.
Okay. And I thought 1 covered it all, so that's where our confusion's
Well, now, you don't have to. If you don't believe that he committed any of these others listed, 2, 4, and 12, you don't have to decide.
Now I see what you're saying. Okay. All right, so we have agreed that there is a violation of 62-19-112, and so what I need to do is ask the board if, do we feel like that there was substantial misrepresentation made?
We agreed on number 1.
Right.
Now we're going to number 2.
All right. Right.
Okay. On number 2.
Pursuing a continued and fraudulent flagrant, whatever the word is, course of misrepresentation, making false promises through agents for advertising or otherwise. Do we feel like that was?
I make a motion that the state prove that case.
Do we have a second? Second by Commissioner Alexander. All in favor?
Aye.
Number 4 has to do with failing to account or remit within a reasonable time any money, commingling of funds. We don't really know about the escrow or the trustee's account, but I think the commingling of funds and all that was.
Well, you don't have to know about the escrow account. The money was supposed to go in the escrow account.
Right.
That's a fact of law.
Right.
It's supposed to be in there, so whether it went in there, whether it didn't went out, the funds have been commingling.
Right.
Because they're gone. They weren't paid.
Right.
And
They were failed to keep in there whether it was one there or not, is what you're saying.
commingling funds, and he's in possession of the money.
Right.
And he kept the funds, and they're spent under his testimony.
Right.
What he's agreed to during court. So
Right.
that is.
So we have a motion from Commissioner Alexander to accept number 4. Is there a second?
Second.
All in favor?
Aye.
Number 12, any conduct of an auctioneer which demonstrates improper, fraudulent, incompetent, or dishonest dealings.
Well, I think it went to the grand jury, and they sent a true bill, and also, I believe it went to court, and the same thing, so I'll make a motion that the state prove their case on number 12.
We have a second.
Second.
Motion by Commissioner Phillips, second by Commissioner Alexander. All in favor?
Aye.
All right, let's go to number 2.
2.
The allegations as to the actions as charged above involving the Trenton, Tennessee Police Department. And I believe this is also supposed to be 62-19-112.
Mr. Chairman, mine says number 4 next. I'm sorry. If you'll get me on the right page, I'll be correct.
You was ahead of them. You always a step ahead of them, though, anyway. Okay. This deals with the Trenton, Tennessee Police Department. 6219-112. B, the commission may suspend or revoke or to renew any license under this chapter for any of the following causes. So now we go back over here and do the same thing and see if we feel like any of these causes were proven or not. Number one, making any substantial misrepresentation.
I'll just interject here again. Since this is the same conduct
Yeah.
that you discussed previously in number one,
Can we do-
it just has a different party against whom that conduct was committed. You've already discussed the conduct and whether it violates these three provisions. So if you wanted to maybe combine them or
Okay, 'cause
decide.
we don't have any new numbers. They're all the same.
Right.
1, 2, 4, and 12.
Right, and it was the same conduct.
Right.
I make a motion that we combine 1, 2, 4, and 12.
As far as
And the state proved the case.
Trenton, Tennessee Police Department goes. So seconded by Commissioner Alexander. All in favor? Okay. All right. And this one's also supposed to be 112?
Yes.
On number 3?
Yes.
Okay. And this is the same charges involving the Gibson County, Tennessee Sheriff's Department. 6219-112B, 1, 2, 4, and 12.
I would make a motion, all are the same.
Okay, motion by Commissioner Alexander, all, second?
Second.
Seconded by Commissioner Phillips, all in favor?
Aye.
Okay, number 4, which was the Wanda Williams and Robert Braswell, 11612B, 6219-112B. Once again, we have conclusions of law 1, 2, 3, and 4, which we have already discussed on the previous 3.
And 12.
Do we have a board would entertain a motion on that?
Are you including 12 in that?
Yes, 1, 2, 4, and 12. Which I believe is the same numbers we've had on the other. Yeah.
I make a motion we do the same as we did on the following, combine them, that the state proves their case. That's 1, 2, 4, and 12.
Second.
Motion by Commissioner Alexander, seconded by,
Me.
Commissioner Phillips, seconded by Commissioner Cunningham. All in favor?
Aye.
Okay. Number 5, 6219-112, the commission may deny, revoke, suspend any license in licensee convicted in a court of competent jurisdiction of this or any other state of a criminal offense involving moral turpitude or a felony. This is 6219-112B6. So this is different from anything that we've looked at to this point. This has to do with the deny, revoking, or suspending a license of any licensee convicted in a court of competent jurisdiction. Does anyone feel like the state proved that?
I'd like to ask a question.
Yes.
What was the, was this a felony?
don't feel comfortable giving an answer to that. I would refer you to Exhibit 6. That's the indictment, and where is the, here it is. Exhibit 7 is the judgment. I tell you what, if you would like to, I would feel more comfortable if Mr. Green answered that question, if you know the answer.
Yes, Your Honor. Theft up to the indictment, 3 counts were theft of property, all 3 were felonies. He pled, two the counts were dropped or dismissed, and he pled to theft of property $10,000 to $60,000. That's a felony charge. And on your Exhibit 7,
So do you know what makes a theft a felony?
theft over $1,000 is a felony.
1,000? Thank you. I think
Yes.
that was their question.
Thank you.
Continues, Okay, so we're back to number 5.
The way I see this, it's number 6 says, being convicted in a court of competent jurisdiction of this or in any state or of the United States of a criminal offense involving moral turpitude or a felony, which Mr. Roebuck has admitted he did. Our attorney has said that, that this would be considered a felony. Of course, I understand 2 of them were responds, but there's still a difference of there is a felony involved, and I believe that has been proven. If I want to make a motion to revoke these licenses, can I do it now?
No.
Okay.
You need to have a
We're still working on our
statutory
conclusion of
basis
law.
first.
Right. We're still working on our
I
conclusion of
believe,
law.
Yes,
he's admitted that he is guilty, so I don't know how you argue with that.
Okay. So,
Now, if you're trying to speed things along, Mr. Alexander. Oh, okay.
I'm just trying to do what you wanted us to do.
Okay.
Do we need a motion of that, or it's been proven, or what?
Did we get through with number 5?
no.
I think you're on
I think
number
he's going to
5.
add 6, too.
So if you wanted to make a motion to accept number 5 as written, then that could be seconded and voice vote approval.
Being proven?
Accepted as written and being proven.
That's what I'd like to do. That's what I was trying to
We
do.
have a motion to accept number 5. Do I hear a second?
Second.
Second by Commissioner Phillips. All in favor? All right. Number 6. And remember, we're still working on conclusion of law here.
Read that out loud.
In addition, under the provisions of 6219-116G, the Commission may take action to revoke or suspend a license when the claim against the Auction, Education, or Recovery Fund has been paid out against the licensee. Section H, the state further provides that the Commission shall subrogate to all rights of judgment creditor in the claim plus interest. And I think that's what that's saying, is we can pay back the $3,000, $2,900, or whatever it was, plus interest to the recovery fund.
Does this go with that?
Yeah, I think this is part of it too. Yeah, the respondent violations set forth above constitute grounds for the commit to suspend, revoke, or renew his license pursuant to 6219-112B. In addition, or in lieu of other disciplinary action, the respondent violations listed in the 18 alleged violations in the proceeding also constitute grounds for the assessment of civil penalties up to $1,000 for each violation. Pursuant to 56. I don't need reading all that.
Well, now, what did you do on number 6?
Oh, that's what I'm working on now.
Oh,
I thought they were still part of number 6.
No, I don't think so.
Oh, okay.
No, that's the disciplinary part.
Okay, let's go back to number 6. Do we have a motion on number 6?
You want a motion that the state prove the case?
That, yeah, well, yeah, and that we
Accepted as a proven fact.
okay. We have a motion from Howard Phillips, Commissioner Phillips, on number 6, that was proven as fact by the state, seconded by Marvin Alexander. All in favor?
Aye.
Okay. Now
Now is when
we
the
get down
discipline, the penalty part
Now
comes
we get
in.
down to the discipline part. Is that right?
So you found all these facts. You found that these facts show that these violations that you voted on were committed.
Right.
Now you need to decide what you think is appropriate,
Action.
yes, for the commission to take.
Now, the state concludes that there were 18 violations of law, grounds for assessment of $1,000 per violation, and this is also the part, say $3,000 paid, that's already been paid out of the recovery fund, and we've got hearing cost and investigation cost, and this is also the suspend, revoke, or refuse to renew license part. So Marvin, I think this is the part you were asking about a while ago.
It might be easier to consider those separately. Number one, talk about if you think any civil penalties need to be, or if you want to talk about action taken against the license first, but just do them one at a time.
Okay.
Mhm.
Okay. All right, well, I will defer to the board. Which one would you like to talk about first?
Well, I think we talked about the license first.
Well, I think if we just took them in order that they are here, that the state's got them, it'd probably be easier for us to keep them straight. And the first one is suspend, revoke, or refuse to renew license as per 6219-112B.
Well, I'd like to just make a statement and give you my opinion at the same time. Can I do that?
Of course, this is the time for that.
I've been in the auction business for 38 years. I have 2 sons, a wife, 2 daughter-in-laws, and just now a grandson that's come into the business. This is the way we've been making our living for all these years. And to have someone that just violates the law and causes people to lose confidence in the auction business is something that I cannot tolerate.
I make a motion based on all the evidence that's presented here, and that Mr. Roebuck's license be revoked and refuse to renew his license until the point that he is paid The payments he's agreed to, he's reimbursed the educational fund, and that he's paid any assessments that might be otherwise given to him in this court, with his license being revoked and not being renewed. Whenever he's all paid up, if we issue him a fine, he's paid that, paid the drug task force, got out of his 2-year diversionary, that he can reapply and start over.
Do we need to break that down, or could that
I
all?
don't think so.
Okay.
We're not talking about penalties right now, right?
Well,
You want
Marvin,
discussion?
yeah, Marvin said penalties, and
I said if he got assessed anything.
if he got assessed in it,
If he
yeah.
got anything, I'm talking about the license.
Okay, you're right now, we're just strictly
We're not
talking about the
assessed
license.
them. Okay,
Okay.
that's what I thought.
So we have a motion on the floor. I get you made that in the form of a motion.
Yes.
Motion on the floor to revoke the license, and that at such time, the drug task force, the recovery fund, any penalties that may be assessed after this are cleaned up, paid up, that he'll be allowed to come back and reapply and start over
And he's off his diversion period.
off his diversion period.
And he'd have to come before the commission to
Yes.
reapply,
Yes.
Or to apply.
to apply.
To apply, yes.
Is that
Now,
for-
Mr. Green, I'm not, I know some boards and commissions, medical board, for example, have a provision where the license is revoked for a year. Do you believe that the commission has the authority to do what they're proposing here?
Yes, Your Honor. I believe they have the authority to revoke and stipulate.
Provide that the respondent couldn't reapply until all of these obligations were
Correct.
satisfied?
Correct. I believe under the under 112, they certainly have the right to revoke, and then under the general licensing provisions, have the right to state at which point they would consider allowing a reapplication and approval
Okay,
of that application.
okay, thank you. Now, I think it's time for a discussion of Commissioner Alexander's motion.
Okay, so we have a motion on the floor to revoke the license, and then at whatever period that the diversion's done, all the monies are paid back, and any fines that may be assessed when we get to the fine assessing part, be paid, that Mr. Roebuck be allowed to come back up and plead his case to whoever happens to be sitting here at that time.
That was my motion.
Yeah, that's what I was just clearing up.
Come back to get an auctioneer license, to apply for an auctioneer license.
No, I think
Said he had to reapply.
start over, reapply apprentice license. Is that what you're
I
talking
didn't put
about?
the apprentice in there, but I'd say the board has the right to make that decision. But
Whoever's sitting up here at that time make that
I mean, that's the
decision.
way I see it.
Okay.
It needs to be, I think it needs to be a little bit clear whether you coming back to apply for your auctioneer license or you're starting all over.
You can amend that motion. And clear it up.
Actually, we're just discussing it right now. I don't think we've ever had a second on the motion. So, we can,
Discussing it then. We don't get a second, it dies.
well, we're just discussing it right now.
There's no requirement that you go by Robert's Rules of Order.
it's not.
okay.
No.
I thought they told us that one time.
Well, most boards and commissions find it convenient to do so, but there is no requirement that you do so.
So would you like to add to it?
Yes, sir. I would like to add that, did you use the word reapply?
I think he did.
Apply, reapply, he's going to come back with it.
I'm wanting to add to his motion that he will apply for an apprentice license. and go the steps that you need to go to get your auctioneer license.
And that's after whatever fines, penalties, restitution to drug task force or recovery fund or
Yes, sir.
whoever else. All right, we have a motion by Mr. Alexander that Mr. Roebuck's license be revoked, and at some point in the future,
Until revoked until he pays.
well, that's what I hadn't got that far yet. I'm talking kind of slow for the auctioneer this morning. Mr. Roebuck's license be revoked, and at some point, and what?
Not renewed, like the law said.
And not renewed, and that at some point in the future, when he pays back any fines that we may assess after this, the recovery fund, the drug task force, what'd you call it, the diversion?
And he's off his diversion.
Off his diversion, then he'd be allowed to come back up here and reapply as an apprentice and start over.
I'll make that motion.
Okay.
I'll second that motion.
All in favor?
Aye.
Okay. So now, I guess we move on to penalties. The state of Tennessee, according to our notice for hearing and charges we have here, is seeking the amount of $18,000 in civil penalties plus $3,079.50 in reimbursement to the recovery fund plus the cost of this hearing and investigation cost.
You know what that cost is now?
That was going to be my question.
Do we know what the hearing and all that costs? You won't ask me?
No, I said, what are we asking her or him?
Oh, I'm asking Mark that. Oh, we got
But
it on number 5?
That's not costs of this proceeding.
Oh, you were asking?
Yeah, he was
oh,
asking.
You were asking about the cost. No, we do not know what the cost, the investigation cost. We don't have that number. We'll have to get that.
One possibility is,
This is what came out recovery.
yes, is to decide on an amount you think would be fair in light of all the other decisions that you've made, and provide that these costs should be paid up to a maximum of a certain amount.
Cost up to a maximum, a maximum for the cost or a total maximum
A maximum for the costs.
for the cost?
Yeah, we've got $18,000 civil and $3,079.50 that
Now,
the
those
state's
are-
already asking for.
Those are different, yes.
Right, that the
yes.
state's already asking for. What you're saying, we can say, plus investigator court costs not to exceed,
If you want to, you don't
Yeah.
have to do that.
yeah,
But
okay.
you can just say plus the cost.
Yes, you can.
Well, since we don't know the cost,
I think that'd be a good way to put it.
Marvin's.
Marvin, would you like to make that motion?
I'd like to ask a question.
Okay.
How did we arrive at $18,000 in civil penalties?
Okay, now,
It's 18 at 1,000 apiece.
your rules provide that for a violation of 6219-112B, 1, 2, 4, and 12, each of those you can assess up to, from $0 to $1,000. So So you would need to decide how many actual violations there had been, and then if you want to assess civil penalties, again, you don't have to.
I didn't know it was written down. I'm sorry.
Okay, so right now, the state is asking for 18,000, or this is what they're suggesting for us to look at. 18,000 civil penalties, $3,079.50 paid back to the recovery fund, plus the hearing and investigatory and revocation cost of this proceedings. Would anyone like to? Guess I'd entertain a motion for that, or
Mr. Green has just pointed out to me that the actual amount that was paid through the reimbursement fund is not $3,759, but on Exhibit 5,
it was like 322 somewhere, wasn't it?
I believe it is $2,940 on Exhibit 5.
Okay.
That was what was...
So that needs to be changed to 2,940. Okay.
According to what's owed to the task force is 13,820, I believe.
Oh, this was for the recovery. It's already been paid out of the recovery fund.
Oh, but they didn't take his 362, who'd they take that from? On number
If you'll
5.
look on Exhibit 5,
That's what I'm looking at. Somebody else paid we paid other to the state. Did they take that out of our recovery fund, or did the Auctioneer Commission pay it?
no,
Who's
no,
going to pay it?
no, it did not, no, wait,
This looks like it belongs
It's
to something else.
330248.
Administrative overhead bill.
Oh, yeah, that's some,
those are some costs that were paid to the Administrative Procedures Division in the Secretary of State's office. That's part of the cost.
that's part of the investigation and the
And
cost. And all
cost
that
of the
stuff.
hearing, yes.
Okay,
That was paid for
That our
services
little-
of a previous judge.
Okay. Okay. Our little catch-all down here, all hearing cost and,
Right, that would include those other 3 expenses on Exhibit 5. As far as the recovery fund, all that was paid out of that is $2,940.
But does the recovery fund not have to pay back this $362?
No. No, that goes to my office, that goes to the Department of Commerce and Insurance for part of their costs. And so if you assess costs, that would include these amounts. But it didn't come out of the recovery fund.
But it'll be a cost back to the Auctioneer Commission at the end of the year, legal and stuff.
I don't know that it would be the end of the year, probably
I mean,
more-
whenever the fiscal year is up, what I'm saying. Every year, we get a balance, what we had to pay for legislative costs.
July or something.
Right,
So, I
right.
mean, that would just be an expense of the Auctioneer Commission doing business.
Yes, except if you assess all
Yeah.
costs
Our
of
little
regular...
Our little catch-all right here's got that, all hearing and investigatory
Understand that,
cost.
so
Yeah.
we need to, that'll be in that cost. But,
Right.
I mean, still, it's going to be paid by somebody
Right.
at some point.
If you assess costs of the hearing
Yeah.
against the respondent, then that will be part of what he's required to
But we
pay.
just need to talk about the 2904,
Exactly.
or 2940, excuse me.
Right. Well, plus the civil penalties. Right. Because the other little deal's going to get it. But back to where we were, the state is seeking 18,000 civil penalties, reimbursement to the recovery fund, in the amount of $2,940 and plus all hearing and investigatory cost and revocation of the license, which we've picked in there. So
if you've decided you want to assess costs, maybe you could just vote on that part first, and then you could vote on the civil penalty part. And vote on the reimbursement for the recovery fund.
vote on all of them separately. Okay. All right.
I make a motion, we make assessment for the recovery fund, $2,940.
Second.
So, all right. We have a motion to reimbursement to the recovery fund of $2,940 by Commissioner Alexander, seconded by Commissioner Phillips. All in favor?
He seconded that.
Oh, Cunningham, I'm sorry. That's my bad here. All in favor?
Aye.
All right, that is for cost of the recovery fund. I'll entertain a motion on civil penalties or cost or...
Well, I heard the gentleman testify that he has no money and has no way of paying back $18,000 in recovery funds, and I wonder if something less than that could be obtained. I'm just thinking out loud.
Make a motion back to discuss it. I make a motion that we assess a penalty of $10,000 and credit for paying off the other two.
Okay. Have a motion to change the amount of civil penalties to $10,000. All in favor?
Wait.
Can't do that?
As long as there is a reason. See, you only have authority to assess
Okay.
up to $1,000 for each violation.
Right, which would give us $18,000.
I don't count 18 here, but
It's 18 violations.
it is?
Yes, ma'am.
Okay. So if you wanted to assess a lesser amount for those same violations, you have authority anywhere from zero.
Let's say $500 per violation instead of...
You got to break it down per violations.
Yes, there needs to be a rationale, not just a lump sum, we think.
Well, he said that because he's already paid back some of it to Trenton County
Right.
and Gibson County, so that's be a reason.
Okay, so then that would be 8. Okay, I'm with you here.
Yeah,
So that would be 8 that you take off, 8 violations, since he's already paid that, is that correct? And that's where
no,
you're
We're
getting,
just reducing his payments, what I was doing.
I think we got 18 violations, and we were reducing them to $500 instead of
well,
$1,000.
right.
Per violation.
And that would reduce the total to $9,000 instead of $18,000.
you could do, yes, you could do that
That's
as
the way to
well.
do it.
Was that what your motion was, Mr. Alexander?
It wasn't $9,000.
Well, he said 10.
You were close.
Well, I mean, I'm going to refrain, that you make the motion.
Just for sake of easier math, it'd be...
I make a motion that the assessment be for $500 per 18 violations, or a total of $9,000.
And the reason that we're doing that is, like Marvin said, he'd already paid back.
Not the reason we're doing it now. We hadn't voted.
Well, the reason we made the motion, she said we had to have a reason for, a thought rationale behind it. We couldn't just do it.
I know, but you should say my reason.
Well, you said it in the deal.
I said 10, he said 9, so that's not my reason.
Okay, well, my reason is because he's already paid back some to Trenton County and Gibson County. But we don't have a second on this either, so
Well, that
we're
was-
still sitting.
And to clarify
The
that,
judge
that
has
was
done
not
told
my
us.
reasoning for this.
Right.
My reasoning for this was that the gentleman said he had no money, now he has no way of making any money, and I have a little bit of a heart to try to help reduce it in half.
All right, let me just clarify here. It sounds like we have two different motions and two different rationales. Commissioner Alexander has made the suggestion that he be assessed $10,000 in civil penalties.
Right.
And the way he got to that, maybe, was, since he's already paid back the two of the entities, and there were 4 charges each on those 2 entities, right? Because there were, both for Trenton and Gibson County, there
Right.
was Section 1, 2, 4, and 12. So if you don't count those as violations, you don't penalize him for those, since he's paid them back.
Thing is,
That drops it, I see where you're
That
at.
drops it to $10,000.
okay.
Okay, so that's one option. Then the other one that I've heard you state is sticking with the 18 violations, but only assessing a $500 penalty for each of the 18 because you suspect that he will have difficulty paying it. So I think those are the 2 options that you've put out here so far.
Okay.
I withdraw my motion, because it never got a second.
Once you take 10 violations at 1,000, you got your 10,000. That's simple, man.
Yep.
10 violations.
All in favor?
Well, where are you coming up with 10 violations? It says 18.
Because we're dropping the 4 for Trenton County and 4 for Gibson County because he paid them back. So that makes it 10 violations rather than 8 at the maximum fine apiece for each of the violations, which would make it $10,000. And that gives us a reason for doing it and accomplishes both goals.
He paid back all except for one sale for one auction in Shelby County. Is that correct?
Now, I can't tell you
Yes,
what the
way
facts
on.
are.
The way I remember it, he paid back the drug task force, and the drug task force paid back Trenton County and Gibson County. And he still owes the drug task force some
Civil
money.
penalty, we've always voted up here, whether there's any money taken or not, and we voted $1,000, $5,000 fine, had nothing to do with money.
Right,
And we're sitting here talking about, and
$1,000.
I think the world can. But I mean, we're talking about, just put it plain facts, he's admitted stealing this money. I can't honestly sit here on this board and not do something about it. I don't think I was put on here for that.
I think we're all in agreement on that.
To protect the public, and I'm not, have no hard feelings at him, but he made his choice. I have a hard time believing nobody knows when that money's being taken out, what you're doing with it. Either you've got lots of money you're fooling with and just don't care, or somebody's not paying attention to their business. And we're sitting up here to try to protect the public.
So your vote motion is $10,000.
$10,000.
I'll second the motion.
All in favor?
Make a motion, he be taxed with the cost and investigative costs and the costs in,
Of this hearing?
with the account, recovery account. All costs of the case.
Oh, we've already done the recovery one.
No, we hadn't done the cost.
Oh,
$300-something in that cost.
oh, yeah.
And
Okay, we're,
is that, the cost of this is something, is it being paid for somewhere?
yeah, I think we can add that too. I think Marvin's motion is the cost of this hearing,
It's the cost of everything involved with this case that the state's going to pay. Or
Investigation.
Investigation and all.
this hearing, actual cost of this hearing, investigation, anything leading up to this hearing, the $362 for the, when we had them up here the other day, or no, exhibit number 5, is it? Or,
It'll all be in there.
wait a minute. Yep. No, yeah. Can I ask Mr. Green something?
Ask me
Ask
first.
you. Exhibit number 5,
Uh-huh.
can we add that? Can we add the $362.48 of administrative cost, or whatever it is that, administrative cost, division of accounts billing, to when the $2,940 was paid out of the recovery fund?
Those are separate things. You've already voted on the 2940, and you've agreed to assess that as reimbursement to the fund. Now, those other costs on that sheet would be included if you vote to assess the costs of this proceeding.
Okay.
That would include everything.
Okay.
I'll second the motion.
Okay. We have a motion on the floor to invoke the cost of this meeting and this hearing and any investigation cost and anything else that's been involved with it.
Cost associated.
All the costs associated. All in favor?
Aye.
Now, policy reason.
Policy reason.
And perhaps Commissioner Alexander has already articulated a
Yeah.
policy reason in that you're taking this action to protect the public and preserve the integrity of the auctioneer's profession. Perhaps that's what you said.
Okay, can you restate what you said there a while ago as a policy reason, Marvin?
To me, the reason we've reached these decisions and voted on them is because we're put on this commission to protect the public. I mean, he's violated the trust of the people he's worked for, and the public is due to be dealing with competent people and people that are willing to stay honest with them. And the profession, the auctioneer profession, gets hurt when anything is done in a violation of our law, and that's the reason I feel like we voted what we did. It's in the interest of the public.
In my opinion, that was very well stated. Is there any law or anything that needs to be added to that? Or
No?
That's just our reason.
We need a second.
Do we need a second?
I'll second Mr. Alexander.
Seconded by Commissioner
Very
Phillips. All in favor?
Aye.
Now, Mr. Green, do you have that? Okay,
Yes, ma'am.
okay. Well,
Where do we go from here?
then I think you're finished. I think you've performed your task very well, and what will happen now is Mr. Green will write this up in the form, it's called a final order, and then he'll have the chairman sign it, and then he'll have it filed over at my office at the Administrative Procedures Division, and the order will be entered when it's filed over in my office, and it will take effect at that time when it's filed.
How long does that take?
That would be up to
Any
Mr.
idea,
Green.
Mark?
We're open today.
I'll try to have that done this week.
And then, that is a final order, so if Mr. Roebuck wants to appeal that to a higher, well, you don't have to decide now, but you'll be sent appeal procedures with that final order to tell you what to do if you wanted to appeal.
Your Honor, does the APD, will your office send Mr. Roebuck a copy, or do I need to send him a copy prior, at the same time I file it with your office?
Well, normally we don't, but we can. When you file anything, you need to send a copy to
Okay, I'll send
to
him a
Mr.
copy
Roebuck.
of it.
Now, it won't have the signature of the chief judge. When you file, it'll get that when it's filed in our office.
Okay,
And actually, they may give you back a copy with his signature when you file it.
okay, all right.
Questions? All right. Thank you all. We're adjourned.
I appreciate your patience with us.
Didn't
Oh,
require.
I'd like to take about a 10-minute break or something, maybe.
Well, I will wish you all a good afternoon and clear out of here.
My mic on. I'd like to call the meeting back to order. So we are at, I guess we need to adopt our, call to order.
Call the roll.
Call roll.
Yes, Mr. Chairman, before I call the roll, I'd like to read into the record the efforts we've made to give notice of this meeting. I'll be doing that from here on out before every meeting. This meeting's date, time, and location have been noticed on the Tennessee Auctioneer Commission's website, included as part of this year's meeting calendar since August the 8th of 2012. Additionally, the agenda for this month's meeting has been posted on the Tennessee Auctioneer Commission's website since February 22nd, 2013. Also, the meeting has been noticed on the Tennessee.gov website since February the 22nd of 2013. And now I'll call the roll. Marvin Alexander.
Here.
Bobby Colson.
Here.
Gary Cunningham.
Here.
Jeff Morris.
Here.
And Howard Phillips.
Here.
Mr. Chairman, you have a quorum.
All right. Has everyone had a chance to review the agenda for today?
Yes.
And if so, do I hear a motion to adopt?
Make a motion, we adopt the agenda as written.
Here's a second.
Second.
All in favor?
Aye.
Minutes from February 4th, 2013. Has everyone had a chance to look at those?
Make a motion to approve the minutes.
Second.
All in favor?
Aye.
All right. Now, I believe the first thing we have up on our list here is an apprentice application, determine eligibility, and I believe we have someone here.
That's under tab 2.
Okay.
Yes,
Let me
Mr.
back
Chairman,
up
if I
here.
could just give a little introduction to this part, and if you
You have to get
gentlemen
me back to the library.
would come up to those microphones at that table. This apprentice applicant, no, if, just sit at the table,
Okay.
it's fine over there. The applicant, and I think I will not read in the name, but you've got the application there in front of you, and if you'll notice on page 3, his answer to question 10 was that he had been convicted of a felony, and so that he is appearing here today with his father and sponsor to explain the criminal record. And the items for discussion are on page 9 of the conviction. Information on the conviction.
All right. So we've got 2 Roberts? Senior and junior.
Page 10 will give you a listing of the arrests, and then the page 11 shows you the dispositions of those arrests.
I guess, Mr. Treadway,
Sir.
well, I couldn't make up my mind. I want to ask junior or senior first. I guess senior, Robin. Of course, I think everybody up here probably knows you or knows of you. And you are going to be your son's sponsor, and this is an apprentice application that he's looking for.
Yes, sir, I am.
And Mr. Treadway Jr.,
Yes, sir.
if you would like to, if it's all right with everybody here, I see you got your high school diploma and you've been to auction school.
Yes, sir. And if it's all right with y'all, I would like to make a statement.
Yes, that's what I was that's what I was leading up to. So you're welcome to state away, I guess.
First off, can I approach the commission?
Sure.
I've got 2 letters of recommendation. Pass them around. I'd like to start off with saying good morning, Commissioner Morse, Commissioner Colson, Commissioner Phillips, Commissioner Cunningham, and Commissioner Alexander. My name is Robert Treadway Jr., and I wanted to first off thank y'all for this opportunity and giving me this time to speak with y'all. As you see by the information you have in front of you, I have made many mistakes that I'm not proud of, and I've embarrassed myself and my family. And given the opportunity, I would love to regain my reputation in my life. And to be honest with you, I had a very bad substance abuse problem. And but I would like to say that I've been clean for 9 months today. And for the last 3 years, I've been working as a ringman at 2 auctions. Mannheim Auto Auctions in Mount Juliet and Dealers Auto Auction in Murfreesboro. And in about 2009, I went to Auctioneers school at Mendenhall in High Point, North Carolina. And I would just like to pursue this career, follow my father's footsteps, you know. And if it's all right with you, I would like to get permission to be able to sit to take the apprentice test.
How old are you, Mr. Treadway?
21.
Junior, are you a slow learner? I'll just sit here and look at these dates.
You could say that, yes, sir.
But you're done, right?
Oh, of course, yes, sir. I was young and I was very dumb.
Dumb is an excuse. Young is not.
I'm still young.
I think a lot of the charges that you see, and they're, it is what it is, and they're not pretty. Most of those charges were lumped into a group.
Yeah, it looks like they were kind of piled up there in a short period of time.
They were, and he had an opportunity to go through the expungement process and get those charges expunged. But what happened is he violated his probation, and they all came to fruition, and now he is what he is.
So you were that close, and then...
Yes, sir.
Are you under probation now?
Yes, sir.
How long is that?
October of 2015, I will be off.
So not only will I be watching him, but he's got another
Set
authority
eyes.
to answer to, which if he makes another mistake, it won't be very pretty at all. Like I know several of you guys on the commission, and I've been in business for 35 years and with a pretty polished record, and any business that he will be conducting will be done under my license, and I can assure the commission that anything he does while licensed will be on the up and up and like it should be.
Ms. Hancock, is that felony question also on the application to take the auctioneer's test? Or is it just on the apprentice test?
You mean on the application?
Yeah.
For the
question
it's on
number.
both. It's on both applications.
It's on both applications?
Yes, it is.
Okay. My point was, is being an apprentice is one thing, because you can't handle any money or anything like that, but then if you decide, you stay clean and don't get in more trouble, and 3 or 4 years from now or whatever, you decide you want to take your regular auctioneer's test, I just wanted to see if that was still on the auctioneer's application too. I wasn't sure, and because it would still come up again then,
Sir.
And because, like I said, anything you do now, if you're allowed to do this, the sponsor is going to have to be there,
Yes, sir.
You said you went to school in 2009 at Mendenhall,
Yes, sir.
and you finished the course.
Yes, sir.
Did you? They give you a test?
Yes, sir. I've got a diploma, I believe, from the school. Yes, sir.
Yeah, it's in here.
But you never
I never
attempted to take
I never.
apprentice?
No, sir. No, sir. That was in my span of.
What was the reason for that you didn't go ahead and do it?
That was in my span of bad behavior, and I just slacked off and never got out, and I didn't have I was lazy. I was lazy.
That's honest answer.
But when you went to school, you said you was under your bad behavior. Do you feel like that you grasp everything that you're supposed to at the school, or did you just?
See, I would love to take a continuing education to refresh my memory of everything that I learned, but
I think the lady sitting right back there can probably fix you up, man.
yes, sir. Yes, sir. To answer your question, yes, sir.
Mark, can you grant somebody an apprentice license that's on probation?
I don't think there's anything that precludes that from the commission from doing that if they're satisfied that.
Actually, all we're doing is granting him the opportunity to take the test if we do it. He still hadn't.
The request before us is to grant a waiver to the application, is it not?
Right.
We granted a guy that got out of jail from Memphis. He served so many years, and so we granted him the right to take the auctioneer's test. That was a long time ago, but I remember.
So you haven't taken your apprentice test, or
No, sir.
Yeah. Okay.
How long have you been, Robert, been working for Manheim?
3 years.
3?
Yes, sir.
You work every week?
Yes, sir. I work every Wednesday at the sale up there. Yes, sir. And I used to work for Manheim, Tennessee, when they were open on Lebanon Road every Monday and Tuesday. But they closed down. They had to merge with Mount Juliet. So other than that, yes, sir, I've been working for Manheim for 3 years.
Do you do anything other than work the ring? You have another job?
Well, I've actually been trying to buy a couple houses and flip them, try to get into the real estate market. But I would like to actually get my real estate license too, if that's possible. After I get my apprentice license.
So you'll be apprenticing under your father and working in his business or not?
Yes, sir.
Okay. Is this an everyday go-to-work thing, or just when the work's there? Or
It's a dealer-to-dealer auction
Oh, okay.
in Mount Jude.
Okay, I'm unfamiliar with it.
Yeah, Manheim is the dealer-to-dealer car auction in Mount Jude.
Do I wish he could work every single day? Yes, I do. I'm a vice president with the company. I travel. We have 80 locations around the United States, and our goal, his goal, and me to look after him, obviously, is to do some construction type where we could try to keep him busy. If granted this opportunity to get the license, I think would give him more opportunity to possibly get some more jobs in that business. But I think that he is, wants to pursue the auction business as a career. Primarily right now would be just in the automotive portion of the business, not so much real estate until, we can hopefully send him to real estate school and get his license for that as well.
Well, as the father of two boys, 24 and 26, I know exactly what you're going through and can appreciate your position very well. And I would make a motion that we approve the young man's application for apprentice auctioneer.
Do we hear a second?
I'll second it.
I have a motion by Commissioner Morris, a second by Commissioner Phillips. All in favor?
Up for discussion?
Oh, yes, I'm sorry.
Okay,
Excuse me, I got the cart ahead of the horse there,
you did.
Gary.
I think the thing that bothers me greatly is he's only been clean for 9 months. However, the thing that would make me vote for him would be he has 2 good letters, a recommendation, and his dad has agreed to stand good for anything if it went wrong. Am I correct with that?
Yes, sir.
Okay.
Would be operating under my license.
Right.
So if he did anything wrong, obviously it would include me.
Yeah, we can come after you. So.
Yeah, absolutely.
And kind of going along with your school of thought there too, Gary, noticing here that shows me that he is kind of headed in that direction. And I think someone had asked the question earlier that you went to auction school in 2009 or something.
Yes, sir.
And then when I see here you just finished your GED here in this year.
Yes, sir.
So that shows me that he's kind of waking up a little bit and going on. Whereas back then, when you went to auction school at 2009, you thought, well, let's go and get that GED right then, or do what we need to do. But like you said, that was still kind of in the dark years, let's call them. And then but this shows here that with you having just completed this, I know some folks that's done that, and that's not an easy thing to do.
I just really wasn't sure what I really wanted to do in life. I was dumb.
It's a great thing to get your apprentice license under your father, but if you had them under Governor Haslam, it's up to you whether you're going to stay straight and you're going to do the right thing. The only thing now is you ain't going to hurt one person, you're going to hurt 2.
And then also, that was the reason I asked Ms. Hancock the question there a while ago about that, whatever the fatal question is, number 10 or whichever one it is, if it's on the auctioneer application too. So whenever you do, as Commissioner Phillips put, decide one day to put your license under the governor, it's going to be any more discussion?
It's fine for me.
Okay. All in favor?
Aye.
Thank you. Good luck.
Thank you.
Study.
Ressa.
Good luck, buddy.
Good luck to you.
Guy's got a hard road. All right, I gotta get back to the library.
All right. With regard to the seminars and newsletters, we had we had a seminar in February at Natchez Trace State Park, and we had 90 licensees attend. We had some spouses, and we had 2 apprentice license applicants who went ahead and came because they were interested as well. So it was a great success of a seminar. Natchez Trace State Park did not get the quality of reviews that they had gotten the last time we were there, and we had some issues as far as lunch, but everything went well. They were able to feed all the attendees, and everything came together there at the end. So we will be doing the same seminar in Middle Tennessee on May 18th. We're still in negotiation on our venue, but it's going to be up in the Lebanon area.
That'd be good.
Yeah.
What day is that on?
That's on a Monday,
Okay.
May 18. And we will be covering firearms and contracts in the Uniform Commercial Code. So we expect a big crowd. We had a bigger crowd than usual in East Tennessee and a bigger crowd than usual in West Tennessee. We would like to think it was contracts in UCC, but really it's guns. It's bringing
Firearms
people.
is a hot deal.
It's the firearms that are bringing people
Really
in.
hot right now.
But it's a really good seminar, too.
It'll be interesting to see how that location out there, Lebanon, Wilson County out there draws. I bet you have a good crowd out there.
I anticipate we will. I mean, like I say, we've had bigger than usual crowds, and the other 2 venues significantly, like 20% larger. So I anticipate.
Hey, I missed your West Tennessee. The GA and I were going to come and couldn't. But
I'll do my best to try to make it May 18th.
You can.
I'm driving to Middle Tennessee.
That'll be close to home. I'll do my best to
close
make
to
it
home.
May 18th.
Yeah. Well, Marvin attended in West Tennessee, and we're glad to have you, Commissioner Alexander. It is also your favorite time, Commissioner Colson. It's newsletter time.
Oh, God.
And
I did such a good job last time.
I know you did a great job. But all commissioners are welcome and encouraged to participate and contribute
When are we looking at
to
on
the
that?
newsletter. I need to have
Yesterday?
it. Yeah.
Something like that.
By the 15th. And also, I would like, if any feedback from this board of topics we can address or you would like to have addressed in this issue.
If you think about it, shoot me an email on that.
I will. Is there anything on y'all's mind that you would like to see addressed in the newsletter? Anything we haven't addressed in the past, or anything you would like us to remind people of? Escrow account.
Did you say you didn't get a good review on the park?
We did not.
Wonder why.
The feedback that we got, some of it, a lot of us, and I put myself in the same category, are overly dependent on our GPS systems now, and in rural areas, GPS doesn't work very effectively. So there were a number of people who came to the seminar who had difficulty actually finding the seminar. That was one set of negative feedback that we had. The other is that the park itself has not maintained its facilities as well. It's been about 5 years since we were there before.
So you've been down there before and had good
We've been
reviews.
there before and had
I've eaten
really
down
good
there, and
reviews.
It's really good.
And the food was very good. There were some problems. The Park Service has changed their policy on whether or not they were going to have the restaurant open. They had some limitations on how late the front desk was going to be open on Sunday for people who wanted to come and stay in the park. So there were a lot of logistical issues that I think we did get worked out. I mean, but not until right there at the end. I mean, one of them was that they wanted us to have reservations for lunch, and of course, a lot of the auctioneers did not make reservations for lunch. But they were able to come back and say, we can feed everybody that's here. So that worked out well enough. But as far as the facility itself, some of the attendees that went and stayed at the facility weren't 100% pleased with their rooms.
Well, the meeting room,
The meeting room was great, and I think that the refreshments, they did a wonderful job as far as servicing the refreshments and having everything set up and that sort of thing. And you know, once we got the lunch situation remedied, I think they went to every effort that they could there at the end to make it a positive experience. So we just had a completely different feedback reaction to the facility than we did the last time we were there.
I hope when you have the East Tennessee one that you'll consider someplace other than crowded Pigeon Forge this time.
We have what we have done, Commissioner Phillips, over the years is we have tried to actually cover a broad area of East Tennessee. So we have been in Von Orr, we've been in Knoxville, we've been in Pigeon Forge, we've been in Greenville, and this next one I think we are, in fact, next fall looking at going up towards Kingsport.
Be great.
So.
People don't like driving in Pigeon Forge.
And, well, again, we've had good feedback on that location as well, so which is why we went back there. But we try to go someplace different every time and spread it out to the licensees so that the same people aren't having to travel every single time. So.
Thank you.
Back to the newsletter. Any suggestions?
I'll think of something.
You'll think of something. I would appreciate that, Commissioner Morris. That's my report.
Julie?
I've got the legal report here, and the first matter is, have you all found it on your iPads?
Which one is it?
Tab 3.
Tab 3, legal report. You got it, Marvin?
208-61.
Let's roll.
That's the first one.
We're ready.
Okay. The first matter is 2012020-861. The complainant alleges that respondent, an auctioneer and owner of a firm, held several auctions which were supposedly estate auctions, but complainant states that respondent sold handguns without background checks and a vehicle which complainant claims reportedly belonged to someone other than the estate. Complainant states that respondent is not licensed to auction guns or vehicles. Complainant also alleges that respondent acts as an auctioneer for another auction firm where reportedly firearms have been auctioned. Respondent submitted a response stating that respondent has had 2 estate auctions and all items sold were from the estates. Respondent states that respondent has operated respondent's firm since 2011 and has been the auctioneer at another auction firm since 2010. Respondent denies complainant's allegations and states that respondent has done everything according to the law to the best of respondent's ability. Legal counsel contacted complainant and provided contact information for the ATF regarding the allegations regarding firearms. An investigation was requested regarding the estate auctions and respondent's work as an auctioneer for the other auction firm. The investigation yielded information that the firm license for the firm where respondent has been acting as an auctioneer since 2010 has been expired a number of years, a fact which the firm owner and respondent told the investigator they were unaware. It appears that the owner submitted an application to TAC for a firm license in January. The investigator obtained documentation showing that respondent has performed 2 estate auctions, an affidavit from respondent stating that all items sold at the auctions belong to the estates, as well as an inventory list of all items sold at each of the estate auctions. Based on the information obtained, the firearm issues fall under the ATF's jurisdiction, and it does not appear there is a violation regarding complainant's allegations of automobile sales, but it is recommended that complaints be opened against respondent and the firm with the expired license for unlicensed activity, but to dismiss this complaint.
Do I have any questions? Do I hear a motion?
I'm still trying to wrap my arms around what really happened.
What, no.
Apparently unlicensed activity.
What is the other complaint going to be now?
Unlicensed activity, this individual, that this respondent, that the firm is, that this complaint is opened against, is a licensee, is the owner and principal auctioneer of an auctioneer-owned firm of his own, but he admitted in his response, and the investigator obtained information that he's also acting as an auctioneer at a firm that appears to have been a non-auctioneer-owned firm that's license has been expired a number of years, and the owner and this individual admit that auctions have been ongoing there. Therefore, the recommendation was to open a complaint against that firm, which is unlicensed, and this individual who's been running auctions there since 2010 for unlicensed activity through that firm.
Would the new firm be an auctioneer-owned firm or a non-auctioneer-owned firm?
I believe it'll be a non-auctioneer-owned firm. The information I obtained from our complaint coordinator was that an application had been submitted, but a 30-hour course still has to be taken, and the PSI exam has to be taken, and escrow information has to be submitted.
That auctioneer didn't confirm that there was an actual auction firm license
at that
available.
Location before.
How would they run advertising without having an auction firm that they could advertise?
I'm not sure. The way I came across this information was the complainant didn't even seem to be aware that this auction firm wasn't licensed. He just mentioned it in the context of, and there's firearms being sold here. When I sent the investigator, I'd looked up the license and saw that it was expired, so asked the investigator to look into it, and that's how the investigator obtained the information from the owner and the auctioneer.
But right now, if we take legal's recommendation, we've dismissed this case, and if something proves different on the other, then we're not voting on anything on that, right?
This is, I'm sorry, I may not understand
Well, I mean,
you.
if we take your recommendation, we're going to dismiss this case.
But open a complaint against this same respondent as well as that unlicensed firm together, just purely on the unlicensed issue.
The firm and the respondent, right?
Yes, sir.
Okay, so you'll have new charges against those two for the unlicensed activity, but as far as the complaint filed, you found that they were in guidelines for the firearms and for the vehicle.
Well, our laws don't really cover the firearm issue. It has been referred to the ATF. I spoke personally with the complainant and gave contact information for the ATF's field investigator in this area. I can also follow up and send copies of my information to the ATF. It's just that the way our laws are written, there's not really anything I can write him for under the firearm issue. As far as sending the investigator, it did appear from the information that the investigator obtained that the automobile that was sold at the estate auction was part of the estate. There was no evidence to indicate otherwise there.
When you send this in, do you send it to ATF or to TICS?
I've never sent one to the ATF before. In this case, I've spoken with the complainant and given him the contact information for the ATF. I can also forward it to the ATF if you'd like, but I have not done that. I've not had this situation come up before since I've been here, so I have not forwarded it before.
I have a purpose for asking that because sometimes what TICS says is right and sometimes what the ATF says, they sort of disagree.
A whole bunch of times.
I would like, if we're going to have anything sent to ATF, to come before this commission first and be explained to us. We could do that.
Nothing has been sent anywhere yet. I just purely spoke with.
That's
I
good.
just purely spoke
You
with
just
the complainant.
recommended that the complainant refer it to ATF,
I just
right?
said, sir, under our laws as they're written, this would be an issue for the ATF. Here
Not
is a
us.
name and contact information, and I gave that information to him, and he indicated to me that was the thrust of his issues here and that he was going to pursue that vigorously. So, but I did speak with the complainant by phone regarding
Make a
that.
motion we accept legal's advice.
Second.
All in favor?
I have a question.
Go ahead.
Well, you done it now. Go ahead.
Beat your chairman over the head.
Now, can I ask you a question about them?
Sure.
You said they don't have a firm license?
This auctioneer, this respondent does have a licensed firm where his license is affiliated at, but he is apparently also acting as an auctioneer for another firm that does not have a license. His license is held at a licensed firm, but he's also doing work for a firm that does not have an active license.
My question was, is there a reason that I might know about this case?
Not to my knowledge. This was based on a complaint that we received from a member of the public.
I mean, is it not next to my house or something? Sounds familiar. That's what I was trying to get.
I'm not.
She don't know where you live?
I don't know where you live.
Is this close to Oneida or Clinton, Tennessee, or Oliver Springs?
Is it
I
east?
don't want to be involved in it if it is.
Well, we done passed it anyway.
Yeah, but
It appears to be somewhere in that area, possibly.
withdraw my
Next to your house.
Withdraw my second. Can you do that? I want to refrain from being involved in this.
All right, we have a motion by Marvin to
Quite honestly, Howard, that's-
legal's recommendation, a second by Gary. All in favor? And Howard didn't vote.
Howard, the reason,
He's- you're
that's why all the
recusing.
names are anonymous.
You're recusing, okay.
But that's why all the names are anonymous, so that you can't figure it out.
Try to keep them anonymous. All right.
Is this number two go to that case, or is this a different one?
Separate issue.
All right.
Number 2 is 2013-000-201. This is a TAC open complaint based on an anonymous complaint enclosing advertising materials for an estate auction and other auctions which were advertised with the name of respondent. It's an unlicensed firm. The anonymous complaint stated that respondent does not have a firm license but only has an auctioneer's license, and said auctioneer's license is held with another firm. A response was submitted by an individual who is a licensed auctioneer. He states that he recently obtained his auctioneer license in this state and he was operating under the licensed firm where his license is held. The auctioneer appears to only address the issue of not having a firm name and license number on the advertising by stating that he was unaware that the firm name and number should be on yard signs. The auctioneer is a non-resident auctioneer whose license is held at a firm which is located in another state. From the advertising materials submitted, the auctioneer is advertising auction sales for respondent, which provides an address for respondent which is located in a second state, which is different from where the licensed firm is located. Due to the separate locations of respondent and the licensed firm, and due to any lack of mention of the licensed firm in any of the advertisements submitted with the complaint, this does not appear to be merely an advertising issue. Instead, it appears that the auctioneer is running respondent as a firm without a firm license. And therefore, the recommendation is to authorize a formal hearing with authorization to settle by consent order with a civil penalty of $500 for violation of Tennessee Code Annotated Section 62-19-102A1, said order to include an order to cease and desist unlicensed firm activity.
Are they selling real estate or stuff or what?
The advertisements that I saw, one, it said an estate auction. That was just purely a picture of a yard sign that we got from an anonymous source, so that's all that we had there. I will check. I think the other items we saw were household goods and things of that nature. Again, it was from an anonymous source, so it's somewhat hard to... This just says estate auction.
They were having a live on-site auction?
Yes, it gives a date and location. It says a variety of equipment and tools and miscellaneous items appear to be what the list is.
Other state, licensed in another state, but not licensed here.
The auctioneer has a Tennessee auctioneer license. The license is with an out-of-state firm which is licensed in Tennessee. But there was no mention of that firm on any of these signs. There's this other firm-looking name.
Who are they selling for?
It appears to... what do you mean, who are they?
I mean, are they selling, are they just saying, come to this estate auction and not advertising who it was that was doing it?
It has the name of this respondent, which is a business name. I don't want to get ruined.
I understand.
It's not just the auctioneer's name on there. It is the name of what.
So it's Joe Blow with ABC Estate Company.
Yeah,
or whatever.
ABC Estate Company, and that is not the name of the firm where this auctioneer
Okay.
holds the license, and appears to not be near the same location.
Skating the law,
I'm sorry.
trying to skate the law.
It doesn't appear to be merely an advertising issue based on what we've got here.
I make a motion, we take council's recommendation.
Is that the maximum fine under that?
Let me double check for you. The civil penalty range for a violation of 6219-102A1 is $0 to $1,000 per violation.
I'll take 500 for what reason? Just, wasn't that flagrant, or wasn't that?
Well, I'm not sure how many auctions have taken place. This person appears to be recently licensed in the state, but it is going on. So I basically, I didn't have, because it's an anonymous complaint,
Right,
I don't know exactly how many have taken place, if this was the first time or...
But you couldn't tell why they filed the complaint, other than they noticed that they didn't have an auction firm number on there. They weren't complaining that they went to the auction and got ripped off in any kind of way.
No, it's a one-sentence complaint that basically just says they don't have a firm license to operate, only an auctioneer license. So, no, there's no indication of any mishandling of money here, just the license issue.
Okay.
Okay, we have a motion on the floor to go with legal's recommendation. Do we have a second? Any other further discussion?
I just think it ought to be more.
Okay, well, we can make it 1,000. Would you like to amend your motion and make it 1,000, Howard?
No.
Jeff, would you like to amend Howard's motion?
I'm not going to amend his
1,000?
motion. It's been made, seconded, vote on it.
All right, all in favor? Aye.
I vote no.
Okay. Easy enough?
You have that right, sir.
Okay. Number 3 and 4?
3 and 4, 2013-000-221 and 2013-000-222. Complainant was the owner of personal items which were sold at auction by Respondent 1, a firm, at 2 sales, one in May 2012 and one in July 2012. In the complainant alleged that complainant had not been paid from the sales or provided an accounting by Respondent 2, an unlicensed individual. A response was submitted by Respondent 1 stating that the money was sent to complainant's old address and respondents did not know that complainant had moved. Respondent 1 stated in the response that the parties had resolved the issue. Complainant later contacted TAC to state that complainant had received the funds from both auctions, which was confirmed with complainant in a phone call, as well as the fact that Respondent 2 did not conduct any of the auction sales to complainant's knowledge. There is no indication that Respondent 2 engaged in any unlicensed activity, and according to both parties, complainant has been paid. However, Respondent 1 would benefit from a letter of warning regarding timely accounting for or remitting money, and the recommendation is to dismiss as Respondent 2, and a letter of warning is to Respondent 1 regarding Section 6219-112B4 requirement for timely accounting for or remitting money belonging to others, and Rule 0160-01-.01 outlining the duties of an auctioneer.
Were you able to confirm that that money was actually sent when they sent it?
No, there was indication in the file that the complainant had moved a number of times. The complainant said initially that's not why, but the complainant indicated to me, I don't know the relationship between these parties, but from speaking with the complainant was very insistent that this auctioneer did nothing wrong. As soon as the auctioneer was brought into it and it was addressed, it was corrected. He indicated that this Respondent 2 is an office person that does some of these things, and that once the auctioneer was brought to the attention of it, everybody got involved and it was resolved, and the complainant was very adamant that he did not want any,
Respondent 2 was not the auctioneer.
Respondent 2 was not the auctioneer. From the complaint, when we originally received it, when I looked at it, I wondered why one was opened against Respondent 2 as well. It was not 100% clear from the first information we got whether there was unlicensed activity going on, but I spoke with the complainant and confirmed that there was not any bid calling or conducting the auctions, that his understanding was that this was an office person.
Office staff sent checks to the wrong address, and once the auctioneer found out about it, he got it straight.
The indication was that the auctioneer was very quick to take this matter up and take care of it, and I spoke with the complainant, and he was happy with the resolution. So
I move that we accept the recommendation of legal and follow that guidance.
Second.
All in favor?
Discussion.
No, I'm sorry, any discussion? Is that it?
That's it for this month. I do have some of the rules that we've been working on, and I did add to the last page some maybe proposed language based on what Commissioner Alexander had discussed at the last meeting regarding if the time is extended for an online auction past the fixed time, then the auction no longer is included in the exemption in our statute. But I know there's also a number of other things that we've had ongoing talks about, namely the principal auctioneer versus sponsoring auctioneer language, and I know Commissioner Morris wasn't here last month, and so we didn't really we discussed the rules, but I don't know if we want to revisit some of those things there, but I did add in some of the proposed language based on that issue you brought up last month about the timed auctions.
I still don't see why it poses a problem to say that a non-auctioneer firm, if we say what it is, must have a sponsoring auctioneer.
Well, and
If we take that out of there, we'll never control the principal auctioneer of a firm anymore. It'll be every day. Every month we're up. I've got so-and-so, I just forgot to send you a letter.
Well, the reason why we have the terminology as principal auctioneer is to mirror the language in 6219-111, which talks about the principal auctioneer. When Donna's office receives an application, the only thing that is required to be listed on there is the principal auctioneer. There's no mentioning in that paperwork or in the records that we keep, correct me if I'm wrong, Donna, about a sponsoring auctioneer. It is just a principal auctioneer as referenced in this statute and in the paperwork that we get, anything that we keep track of. Is that right, Donna?
Yes. That's correct.
I will agree with that. You know, I'm certainly not disputing that. The problem that I see is, I was on here when they changed that rule, and they put the rule in that's over in there says the sponsoring auctioneer has changed all auctions. And I always thought that when you made a rule or a law, it was got down to the intent of it, whether it was typed just right or not. And if you went back and checked, the reason that rule was put in, and for all these years we had that clean. We didn't, it was ruled on that way. But, and it was done to so that where the real estate companies, and that's where we even had a gallery license, and a auction house, had a way, if they weren't an auctioneer, that they could get in business. That was the reason it was changed. That they went to school and they got an auctioneer to sponsor them, just like sponsoring an apprentice. That's the reason it all came about. And if we had in there that a non-auctioneer firm must have a sponsoring auctioneer, and you could go ahead and say that in another line that the sponsoring auctioneer, the non-auctioneer firm still has to have a principal. It could be one and the same, or it could not be. But if it wasn't one and the same, then that sponsoring auctioneer still had to attend all the auctions. Of course, when they made the gallery license, that did away with the problem with the auction houses. But right now, if you change this, anybody in the country that I see can go and take and just go take that and take a test, and they'll go take the test and get them a license, and then they'll designate somebody as a principal auctioneer.
Would it be possible just to, because when we make our rules, they have to be based on our statutes here, and since there's no mention of sponsoring auctioneers being utilized in any capacity except as a sponsor to an apprentice, what if we keep the same terminology as a principal and then try to beef up the requirements of the principal to make sure that when it says under 111 you must have a principal, clearly outline and specify each and everything that principal has to do? Because in these statutes, I'm just not seeing where there's a requirement of a sponsoring auctioneer at the firm. I'm only seeing the requirement of the principal.
Well, I understand that. If you can beef that up, yes, that's fine. But I'm afraid what's going to happen is you're going to take a company like Bobby or like Jeff, and we're going to beef up that control of the principal auctioneer. He's got to be here. And pretty soon somebody's going to say, well, you know, that principal auctioneer has got to be at every auction for anybody, for a licensed auctioneer, for a licensed-owned company. Well, if he has 2 sales at once, the guy can't be in 2 places at once.
And how is that handled right now through a sponsor? Does a sponsor go to one? Because you're saying the sponsor.
I'm not talking about as long as you keep the sponsor just with the non-licensed auctioneer firm, you have no problem. He has to be there. He's not going to be where he can run 3 auctions at once. But if they've got 10 auctioneers, and some companies do, and they want to do 2 auctions at one time, you don't want to get this thing where they got to have that principal auctioneer trying to say he went to all those auctions. And that's eventually what will happen. In other words, you're just going to make it harder. You're going to make it where the person that is an auctioneer-owned firm so tough that they may not can do business like they've been doing. That's my opinion.
Well, I think you're exactly right. And like Saturday, I've got 3 auctions, so I got to have 3 auctioneers in 3 different places. And
you go to one, can you go to one?
And Brian.
Right.
And if you tied my feet, like Marvin is saying, we could only have 1 sale.
I know that's not the intent, but it's just like, see, we went through all these years with that, relying on that rule that said the sponsor and auctioneer for a non-auction firm had to obtain these sales. And then it got changed last year, year before last summer. It had never been a problem before.
It's still in the rules.
I know, but we're not going by it.
Hey, Marvin, could you not just say that they're responsible? Not that they have to be in attendance, but they're responsible for...
As long as you write it like what the intent of that was, I mean, but how many times have we sat up here and talked about the firms, you know?
I think it goes back to what we were talking about once before about, and it's you got to be careful. I'm like Marvin, you got to be careful when you do it, but definitions, just a better definition.
But as long as it comes under a non-auctioneer firm, I don't see the difference in a licensed auctioneer sponsoring apprentice than it does coming under a non-auctioneer firm, just saying what it's supposed to be.
And he could be the sponsor of more than one firm, is what you're saying.
Well, that's not been voted on. I mean, I don't know. It doesn't really
Right
in
now,
theory.
Right now, I don't think we have a prohibition against that in our laws.
But if you look on page 7, you know, and they take different. That's where they're coming up, and see, we were trying to expand on that in the rules. It's in here that in the rules.
Well, the way Julie has worded item 3 on your proposed rules there in front of you, it mirrors what the rule says, that a sponsoring auctioneer shall attend all auction sales. It just says that the non-auctioneer-owned firms, principal auctioneer that they appoint shall attend and accept responsibility of all. They don't have, the non-auctioneer firm doesn't have to pull in the principal auctioneer of the auction firm and name him or her the principal. They can name an auctioneer as their principal who has to stay and be at all auctions. That's the way I read item 3.
Yeah, but that's what I'm saying. Whoever's responsible for that firm, they could freelance what they do. And that is not good.
Well, they can already bring in any auctioneer to call their auctions.
They can do that, but that sponsoring person has to be there.
Well, they're one and the same.
Not necessarily.
Well, but they don't have to be the principal of the firm.
And they don't have to be, but if a non-auctioneer firm is sponsored, right now, the way it's supposed to be set up, is that they could just designate me. They can designate John Blow in Memphis. Next week, they can designate somebody else. Right now. I mean, if we do this, that's the way I see it.
What I'm trying to accomplish here, and I may need to clean it up more to do this, is I'm trying to make it so, because the statute requires the commission to have on file who the principal auctioneer is, we take the responsibilities of what you're calling a sponsoring auctioneer, make the principal auctioneer do those things, and then that way Donna's office has on file for those non-auctioneer-owned firms, hey, who's the guy that's responsible here? Okay, it's this principal. It's just that the statute...
Are you going to go ahead and make him sign that applications with him before he gets a license that he's the sponsor? See, the way I read this, you're going to let whoever gets the license just appoint somebody. That's what it says here.
As long as they're an auctioneer.
They'll have to register someone as the principal auctioneer, and that would have to be on their paperwork when they submit it, which right now they're already having to do is list somebody as the principal on their paperwork. My attempt here was to have that person who's listed in the paperwork have more responsibility. Because if we start making rules that set out lengthy requirements for sponsoring auctioneers for non-auctioneer owned firms, my worry is that when this gets to the Attorney General's office to look at it, they're going to go back to our statutes, and I understand they may used to have been different, and they're going to go, wait, we don't see a requirement that there needs to be a sponsoring auctioneer. They can look here and see there has to be a principal auctioneer.
Trying to match the rule.
Because I'm worried that if we use a term that's not being utilized in our licensing statute, they're going to go, wait, where are you getting this from? So I'd like to take the responsibilities of whatever you all think this sponsoring auctioneer needs to be doing and put that on the principal. That way we can say, hey, they've got to be listed on here, and take our rules and say, here's what they've got to do. If that makes any sense. And I may need to do a better job of cleaning that up, and that's what I guess, since I'm not an industry member, I need y'all's help with. But my goal in wording this the way it is so that it lines up with our statutes as currently written, because when the AG's office looks at these, they look at the authority, and they are very exact. I've gone through this with real estate. They go back to the statute and look and say, wait, where are you getting the authority for this? And I could just possibly anticipate the question of where are you getting this sponsoring auctioneer for a non-auctioneer
Ask you
firm?
this: if this passes like this, and there is a problem come up, who? And you read this, that the principal auctioneer on the non-auction firm's principal auctioneer and shall attend and accept responsibility for all auctions for the firm. Whose license are you going after?
I would think the principal auction, because it's putting the responsibility for the...
Well, why don't you go after the firm license too?
Well, we could open complaints against both of them.
What I'm scared of, if you don't spell that stuff out, it just looks to me like it's going in the Bible. You just pick out a sentence now, and everybody's picking it out, and this proves this point and it don't. I just hate to see this thing gets more complicated where you can't do business.
So what about, do you think that the principal auctioneer should not have to attend all sales?
Both of them should. Firm license and the principal.
Okay. And accept responsibility along with the firm for all auctions? Maybe what about the addition of that, to say, shall serve as the non-auctioneer-owned firm's principal auctioneer and shall attend and accept responsibility along with the firm for all auctions for the firm at each location.
I want to just prosecute your auctioneer and not get the guy that owns that firm.
Okay, I can add that in.
Look after our own.
Right, no, and I can certainly add that in. And are there any other parts?
Can't argue with that.
are there any other parts to this that you all see? Because I understand that how it's been is there has been this sponsor, but I'm trying to take those duties and line them up here, so if there are other issues with that I can address this better, that's what I'd like to know. And we can, by all means, take another month to look at it, because now it seems like we're kind of coming to an agreement on what we need to do here, and we just need to be sure that these rules are as clear as possible. So to avoid problems like Commissioner Alexander mentioned, we can look at it one more month, because I tried to take this from other places to make it as clear as possible, but you all may see problems with it that I don't. And I can add in that along with the firm language in there, but there may be other things you all see as well.
Why don't you add what Marvin
I'll add that
said,
in.
email it to us again, and let's look at it again.
Okay.
One other comment I'd like to make.
Okay.
You know, I brought up, I think, about the livestock auction sale barns,
Yes, and that's,
the facilities or what.
I've got that on the last
I
page.
see it.
Do you need some, do you think something?
I just think that we don't want to do anything to affect the livestock auction facility. But, you know, about 2 months or 3 months ago, Miss Donna, you wrote stockyards and Packers stockyard. I just think there needs to be one more section on there that says any livestock auction facility selling items or those items that exempt that are not regulated by the Packers and Stockyard Act shall require a Tennessee licensure, just like what anybody else have to do. Because didn't it come up with, they didn't have to have a license to sell chickens, they didn't have to have a license, maybe it was goats in it.
They
and stuff.
auction off tack
Tack and all
saddles
that
and
kind of
other
stuff,
equipment, too.
You know.
Okay, so take out what's in here and
No,
keep
leave
that.
You got it good.
And then maybe do another subsection, and let me repeat this back to you to make sure I got it down right. Any livestock auction facility which is selling items that are not exempt shall be regulated by the Tennessee Auctioneer Commission. Did I get that right, or do you?
I just think you need to dress it up a little bit like that letter she got back from them.
Okay.
And it needs to say not the facility, but the person running it.
The operator of any livestock.
And the facility, if he's got a different, if they're not putting the money in the Packers and Stockyards, they come under us.
Okay.
Huh?
Include the operator.
But if we could find that, you know.
I've got it.
I'll take a look at that letter, and I will try to work on this language, and before I send it all out to you all, I'll try to work on that in there, and then you can let me know next month if you have any more thoughts on that as well. But I'll try to work on that in this before I send it to you all.
Yeah, that's a great point, because there is a couple of horse auctions that I know of. They sell two horses and then sell for till 2 o'clock in the morning on everything else.
I think they could still do that if they run the money through the Packers and Stockyards account. But they're tougher to
I bet
beat
you
on.
ain't running it through them.
But if somebody goes up there and just has a sale of just the tack and stuff like that, or they leasing the barns, there's not many markets in Tennessee now. They're leasing them to somebody else. There's very few livestock sales across Tennessee. Lots of facilities. So,
I'll work on that stuff for next month, and I'll get it sent out to all of you all well ahead of time for you to look at.
I have one question, and not to beat this to death, but I just want to make clear that if we have a non-auctioneer, according to these rules that they get passed and proposed, if you have a non-auctioneer-owned firm that applies for a license, they can appoint or designate an auctioneer as their principal. They don't have to go and designate someone who's already a principal for a firm. They can call an auctioneer their principal.
no. I mean, the reason we put that rule in was so they couldn't freelance. Whoever is their principal auctioneer's that's in those rules. And until somebody says it's wrong.
Yeah, it can't be who you cite it is today. It's got to be somebody that's going to be
Unless somebody
signing up and
decides that's
accept
wrong.
that responsibility.
Kind of along the lines of a principal broker in a real
Exactly.
estate firm.
Exactly.
Well, if they bring him in full-time and he leaves your firm, and they bring him
They
in,
got 10 days to get another.
Do what now?
They got 10 days to get another principal auctioneer.
The non-auctioneer-owned firm does?
Yeah.
It said all advertising of an auction sale by an auction firm not owned by a licensed auctioneer shall include the name of its sponsoring auctioneer, and the auctioneer shall attend all auction sales.
Right,
I
but,
don't know how clear that could be. It's what's
well, it's who they're designating as their principal that's unclear to
a
me.
sponsoring auctioneer, when this set up, they didn't have the right. They agreed with them, and the people signed on as their sponsoring auctioneer. Now they could hire somebody else, and the firm could be a principal, but that sponsoring auctioneer had to be there. That's the reason that was put in. Now maybe we messed it up, but it worked for a lot of years. Worked up until year 4 later.
If you lived in South Carolina and you're a corporation or something, and you want to open up an auction in the state of Tennessee, that's legal and good to go. So you say Marvin Alexander is going to be my sponsoring auctioneer. You write his name down.
I get one of Marvin's employees away from him and bring him in.
You get who you want to. Give me a name. Who you want to be your
John
auctioneer.
Smith.
Okay,
who
John
is
Smith's going to
an
be
auctioneer.
your sponsoring auctioneer. John Smith is supposed to be at every sale you conduct.
That's good, but John Smith was never a principal for any other firm. Okay, that's my
He's got an
point.
auctioneer license.
That's
though.
my point.
I have a full auctioneer, he's got to agree to be the principal auctioneer of that firm.
That's all I needed to know. That makes it clear.
And if he leaves, he's got 10 days to get another one.
Here's the essence of the problem. In the code, in the statute, there is nowhere where it talks about people responsible for auctioneer firms. In the code, it does not mention sponsor, except where it talks about an apprentice license being sponsored.
Right. It uses the word principal and all the rest of it.
It uses the word principal. All we're trying to do is match the rule to the code.
Right.
So that there's no question. Now, as we go into this, it appears
We might not be able to do that.
Well, just put in there that if you do put this, that the principal auctioneer, if you're going to change the word sponsor, he has to agree to be the principal auctioneer for that firm and sign on.
Right.
And do you want...
Right, he has to, accept that responsibility.
You don't let the guy go and get his license and then say, well, I'm going to designate Joe Blow over here.
Then we have in this subsection 3 of this rule that I'm going to work on some more, it does say that he shall serve as the principal auctioneer and shall tend and accept responsibility for the auctions. Would you all also be in favor of there being some sort of specification of this person being responsible for the management of the firm and the advertising and things like that, et cetera, or do you think that that's already covered over here in this publication, this rule that says the advertising shall include the name of the sponsoring auctioneer?
I think that's already covered myself. I don't know.
To make it a little clearer, would you all be agreeable to amending this rule to change this to principal auctioneer to align with the other rule? That way it's all called principal.
I think you got to keep the semantics as similar as you can possibly keep them in order to avoid the confusion with the public.
Okay. I'll work on that.
What is the difference between a principal auctioneer and a sponsoring auctioneer?
You've opened a can of worms now, Hal.
May not be any difference. It's depending on whether
Depends on which situation you're using
it's
it in.
depending on whether it's an auctioneer-owned
Somebody needs to
firm or a
know.
non-owned auctioneer
That's
firm.
what we're working, that's what
Somebody
we're
needs
trying
to
to
It
do.
doesn't sponsoring apprentices or not.
I was thinking just need a principal.
Yeah,
I give up.
Exactly. That's where we're headed.
Just do the
But you
rules
look
and
how
send
you
them back out.
you look how many problems we have over firms. The
write it up and
biggest
send it
problem
back
we
out.
have that I see
We can be
is we
here
need
at
something
midnight.
when you renew my license that there's something signed what firm I'm with, and it's verified each year before you send out the license. There's lots of people that are on somebody's firms in this state's done retired or dead. Used to be.
All right, so
They're retired.
you're going to rewrite it and send it back out to us, and we'll...
And the goal here is get us adopted by next month.
We'll get them.
I'm talking about by this commission.
Yeah, we're moving forward. We're getting there.
All right.
I'll work on it. I will.
You have your comparison report, Donna?
Do, and before I go into that, I just want,
Can I just tell them one
Yes.
thing before you go? I did want to let you know that we received a signed consent order with a payment of a $500 civil penalty from the apprentice auctioneer that we discussed last month that had the unlicensed gallery. So that has been
Good.
paid. So just wanted to let you know that. Go ahead,
Thank you,
Donna.
Judy.
Miss Donna, can I make one, I wanted to tell you.
Sure.
This seminar, reason I said that about TICS and ATL, at that seminar, the other day, the gentleman does a great job from ATF. I can't think of his name, but
I know he's
they've
gone,
used
man.
him several times. He made a comment, and I asked him about it after, and he said it's right. I know with several of the seminars that I've been in, and I've even had a person when I call tell me this, that if I'm having a gun auction and you brought your gun up there, me sale walked in there that day, I registered it or I set it in a rack, you stayed there during the auction, I didn't sell it, I could give it back to you. Now the gentleman said the other day that was against the law and he better go in whoever's books that was running that sale.
oh, in the books,
I mean, my dealer book.
If you're taking it to a FFL,
Well, I'm talking about if I'm having a consignment auction where I have a license,
yeah.
you know, that I have to put it in my books, and then I have to check him out. He has to pay. And if he's got a problem, he don't get his gun back.
Right.
And then it was asked about, you know, something you were wanting the other day, that we put a specific number, a thing on our website. He said that we wanted to, if you have a problem, if you're an auctioneer, you sure don't want to listen to your feller auctioneer.
That's for sure.
You don't want to listen to your feller gun, who's selling guns, and you want to, what you've read, you need to call the ATF personally, and that we surely didn't need to put nothing on our website except the law, and let everybody make their own decisions. That's what he
I think
said.
that's good advice.
And I made a statement at the last commission meeting, and I'm going to repeat it. If you don't go with these laws, some auctioneer is going to prison.
Yeah.
It is serious.
I did a sale 4 years ago with my consignment lot. I'd moved my gun license, had no gun license. Had a gentleman bring his equipment in, his car, his other stuff, and I'm selling it. He's going to move. He had a 9 to 12 guns. Since I'd moved my license, I called to Nashville and talked to him and told him this man had 9 to 12 guns, but my license had been moved uptown. Did I have to carry them up there and put them in my dealership and issue them from there and check them out? They told me, since I was not taking other consignment guns, that on that one isolated case, I could sell his guns there and didn't come under the rules of my dealer's license. So, and that's, if this guy took those guns in that sale, that's the same thing he did.
Well, I had a call from the ATF week before last that asked me, under the auctioneer laws, if an auctioneer who is auctioning off surplus property from law enforcement agencies in a certain county was exempt from being an auctioneer to auction these weapons, but that this guy, who he was specifically calling about, was also auctioning not just the surplus weapons, but weapons for citizens who walked in off the street with them. And I said, look, the auctioneer laws don't address any of that specifically. You're the one, the ATF, that decides what he can do and can't do at that sale. So I think a lot of them are confused and think that the auctioneer laws distinguish and set out what you can sell in the way of weapons at an auction, and whether you're a dealer or not, but they're not specific. So he had to address that issue himself. Are we ready?
Complaint comparison?
Yes, and I just want to tell you, I don't have a budget report for you this month because I didn't get the budget report from administration until Thursday, and I didn't have time to put that together because I was not here Friday. The complaint comparison report, top block, is from February 28th of 2012. The bottom one is this year, February 22nd. You'll see last year we had 86 complaints pending at the time. This year, 59 complaints pending, a lot lower, and the ones, too, are over 180 days this year. Thank Julie and Mark for doing a great job in getting those down. If you don't have any questions on that, I'll move on to the report from your testing vendor, PSI. Last month, I asked you if you would consider extending the contract with our testing vendor, PSI, for one more year. There's a clause in the contract that allows the commissioner to extend the contract for 1 year at a time for a period of, I think, of 5 years. But we thought it best just to bring it to you and get you to your opinion on extending the exam. You asked for these statistics, so I contacted PSI, and I have 2 years of statistics to show you there. That top page is from January 1/11 through 12/31/11, showing that your apprentice auctioneer applicants were 57 to take the exam. 92% of them passed the first time. 4% failed the first time. There were 4 repeat passes at 66.67%, and 33% of the repeats failed. So then you're going down the line there, the auctioneers, there were 26 that took the test, 96% passed. Galleries, 10 took the exam, 10 passed the exam. And on the next page over, the non-auctioneer firm applicants were 4, and 4 passed the exam. That was in 2011.
Are you pleased with the job they're doing?
I am. I get very few complaints against PSI, and that was another thing you asked me to find out was what's the nature of the complaints that PSI gets from exam candidates. And on that last page there, under that tab, Mr. Dabsis answered that question and said that in 2011, no escalated calls came to them from the Tennessee Auctioneer Commission. But in 2012, one call escalated to a lead or supervisor, and the complaint was that he was turned away from the site because he didn't have the required documents. And that was one complaint. He said we also received this one comment from a candidate in 2012. All of the internet referral links used for reference were broken links or for outdated web pages, making studying accurately difficult. And then on number 3 there, where my question was, what % of test takers were turned away at the test exam site for not being prepared? He said C2 above. There was just that one in 2012 that he already reported. So
They're cost competitive, and you like them. I don't see any reason why we wouldn't
there's
extend.
no cost to this commission for the exam. It's a cost passed along to the applicant, so it's a note.
You're happy, I'm happy.
I'm happy.
We just need a motion from you all, if possible, about whether to
Make a motion, we extend the contract for 1 year.
Second.
Thank you.
All in favor? Any discussion?
Done discussed it.
All in favor?
Aye.
And we have one other issue under my report. It's on tab 7. This is an application.
I need to recuse myself from this, but I will be here to answer any questions if anyone has any.
Wilson will recuse himself. This is an application for a public auto auction firm from Auto Auctions, Inc., here in Nashville. With the application is there. Mr. Edward Colson and Mr. Robert Colson are co-owners, I think, of this business. I believe that's...
And Mr. Williams, too.
Yes, shown on the application there. There's a copy of their Davidson County permit, commercial district, their auto dealer's application license in there, their bond, their insurance, financial statement. So if you'd look it over, please, and let me know if you are willing to approve this application.
Everything in order. Any reason why this commission should not approve this application?
None that I see, sir.
Motion that we approve.
Second. Question.
Oh, no.
Has any of the officers ever been upset? Mainly Mr. Williams.
Take a fifth on that one. That's one question I don't want to ask.
Both are also licensed public auto auctioneers. So.
Well, this is not the easiest thing in the world that you've ever done. If you look at all these pages, how many miles did you put on your car doing this?
I don't want to talk about it.
We made a motion in second, didn't we?
All in favor?
Aye.
Aye. Maury. Motion passes. Since you abstained, you couldn't call for the question.
Don't be a knock for selling them cars in any public auto auction.
Yes, sir. I'll stay out of knock. Do we have any unfinished new business or unfinished business?
That's some new business.
Do we have some folks in the back that would like to speak? Mr. Worley? Okay.
I don't know. Okay, it is on. I'm Michael Crawley. I'll cut to this as quickly as possible because I know it's been a long morning, but I do appreciate.
What did you say your last name was, Michael?
Crawley, Crawley. I do want to mention that I appreciate what you guys do. It's the first time I've ever had the cause to be here, and I think it ought to just about be required for people to have to come up here and see what this process like. It's very enlightening.
Today's been a little more interesting than most.
Oh, well, I can see that. Yeah, it is. It is interesting nonetheless. My licenses are expired. They expired in 2011. There were some extenuating circumstances, but I'll skip through them based on the fact that I don't want to shirk any responsibility for it. I understand my responsibilities. What I'm up against is the requirements to renew those licenses now. There is a $225 renewal fee and a $200 late fee at this point. They're less than 2 years.
When did they expire?
The Auctioneers license expired June the 30th, 2011.
6/11.
Yes, sir. Then the firm license expired December of that same year, which obviously it was invalid at the point that the auctioneer license expired.
June 30th, 11. Was
yes, sir.
Expired.
What I'm looking for.
Chart handy.
It's in the back of your book. Well, is it in there? iPad?
It's in the
on both.
My iPad just don't like me today.
The charts are in the folder and the iPad.
It's charts.
Also in your folder.
There we go.
Paper.
Terms gallery.
Auctioneer.
So the license you're discussing is your auctioneer and your firm license, both?
Sir.
Okay.
The problem that I've got is as I understand it, the 30 hours of education that's required to renew those licenses, I can't find a provider that doesn't do it any day of the week outside of Friday, Saturday, and Sunday. I have a job in Kentucky every single Friday. It's 3 different places, but
Let me stop you and ask you a question.
Yes, sir.
Have you been conducting auctions during this period of time?
The only ones that I've done have been under the direction of a government entity. which is exempt by 6219-103. Outside of that, everything else, that's the only ones that I've done as an auctioneer. Now, I've been involved in the business as a ring man, but that's it.
These been expired for how long?
Can you not get them online?
No, sir. No, that's what I thought. Even to the point, it also requires 6 hours continuing education. I became aware of the issue with the licenses having been expired shortly after the firm license showed to expire. It's been January of last year. In anticipation of being able to go through this process the normal route, I went ahead in February of last year, went to Jackson, Tennessee, got the 6 hours of continuing education offered there at Union University at the state seminar. Since then, as I say, I've been unable. They don't offer the 30-hour course online. Most of the online providers, they have ways to get 6 hours, but the 30-hour course it's the course that you take at the end of your apprenticeship, basically, and it's an in-class type of thing. And I guess with it being a 30-hour course, it just becomes most convenient for them, for 99.9% of the people that need it, to do it on a weekend. It just
all day Friday, all day Saturday, all day Sunday.
Yes, sir. Yes, sir. Some of them are Friday, Saturday, Sunday, Monday, just depending on how they bust up the hours. But it's always over the course of a weekend, and which is always including of a Friday. According to when I called the last time up here to the office, and I believe I spoke with Ms. Gloria. She, as I understood it, said that I needed those 30 hours prior to the retest and the reapply. That's the reason why I came here today, was because it says specifically that the commission can waive it can waive those 3 requirements: the re-educate, retest, and reapply. As I understand it now, apparently what I was maybe supposed to do was to reapply and then petition the commission for the option of waiving the education and retesting. I'm not really, like I say, I'm not really certain.
How long have you had an auctioneer license?
I was first licensed in 2008.
2008?
No, sir, 1998. I apologize.
1998.
Yes, sir. Yeah, and I've never been delinquent that I can recall prior to this time. And
they've been expired since
2011. June 2011.
A year and a half.
Yes, sir. And it'll be 2 years at the end of June.
How does it make any difference? He served his apprenticeship under a grant.
That's questionable.
But I mean, how do you go a year and
what happened?
8 or 9 months? And
that's what happened.
Now catch it. That's what's.
Well, no, I caught it January a year ago. Like I said, I've been in that time period.
What have you been doing last year?
But at that point, what I was saying is that I haven't been doing. I work along with Jay. Jay is fully licensed. He's done
all
of
that, but I mean,
he's
my
done all
point
of that.
is
what I've been
looks
trying
like it'd been working Friday, Saturday, and Sunday somewhere in the last year to.
Well,
like, hey Jay, go get somebody else to help you.
Well, no, there's other.
The question is his Friday auction is with insurance auto.
Right, working as a ringman, they're separate sales. In other words, it's not a situation where each one of those, they're in 3 different places. And it's difficult to tell a fellow that I'm not going to be there when he only has you hired to work 1 day a month at his place. That's what it all comes down to. In other words, part of the deal is not missing those sales.
Work 1 Friday a month?
No, sir. I work every Friday at 3 different places.
Oh, I see.
In other words, so there's one every week.
I understand that's difficult, but it's difficult to let your license expire.
Yes, sir. Well, that was what the license expiring situation. That's what I say. I wasn't going to mention because I don't shirk any responsibility for it. I filled everything out and wrote the check. I had a secretary that I assume she's telling me the truth, that it fell down between the console and the seat of her car.
Mine does that a lot.
And the difference was when she figured it out, she covered it up. That was how it got so far out. Even to the point of arranging for the bank records to show appropriately that the amount of money came out. Obviously, she's no longer working with me at any point, but That was how we got to the point of around January of last year, when I started checking to see about my firm license. I knew the one that I had expired in December.
Do you send
No record of any of
notices
it.
when license expire?
We send them out before they expire.
Okay.
Give
I know I
them
get
60
something.
days.
You get a renewal notice.
Yeah, got the renewal notice, right. But see, all of my mail coming in was going across her desk, so she was in the perfect position to hold any further notification. I don't know at what point she figured that she would be able to straighten it out.
But that's been like a year ago.
Yes, sir. And like I say, in that time since, there's about 4 or 5 providers. They don't have this class, most of them, but twice a year, maybe 3 times, depending on the one. So even that times 4, maybe 12 times a year, it still comes down to once a month, but not on anything but a Friday, Saturday, Sunday. I don't have any problem with the fees and penalties. I don't have any problem with the course. I understand that it's required. I just can't seem to figure out a way to get that 30-hour course done.
I would like for the council to enlighten me on this situation. I don't know.
Well, you have a rule that covers late renewal of a license. It's Rule 0160-01-.22. Do y'all have a copy of your rules? Subsection 3 of that talks about applying to renew a license 6 months or more after the expiration date thereof, but less than 2 years, which appears to be the time period that he falls within. Subsection 4 of that states, upon written submission of good cause shown, the Commission may, by a majority vote, waive any or all of the penalties and requirements in paragraphs 1 through 3 of this rule, including but not limited to re-examination and additional education requirements, or in lieu thereof impose other such reasonable conditions or requirements as it deems appropriate.
Does our little chart cover this? This is what our, yeah.
Yes, and I think Donna did prepare a chart based on that.
I'll be honest with you, there was much noise going on. I could only hear about half what you said. In your own words, just tell me what you said.
What did you say?
I didn't catch your number. What number is that in the rule?
It's Rule 0160-01-.22. The title of it is Late Renewal of License.
Page 10 of your rules, guys.
And the subsection 4 was the one I read aloud of that.
About 3/4 of the way up.
Same like this.
So what that says is if the commission so wanted to, they could waive the whole thing.
It says upon written submission of good cause shown. So he may have jumped the gun a little in coming in here, but that does appear to be a provision that's contemplated within your rules.
Up to 2 years, you have the authority to waive the 30 hours, the retesting, and so forth. But after that 2 years, you don't even have the authority to do that. Luckily, he falls under that 2 years, but as Julie said, he jumped the gun because this is the first I've heard of this. Normally, they file an application with me and they send a written request, which I bring to you to consider waiving those 2 items or not. But since it
That's why I mentioned that when I called and spoke with Ms. Gloria before, I was told the other way around that the 30 hours needed to be completed prior to the reapplication. So that was when I thought, well, then I have to come here first to get that waived.
Unless you've written and saying, I want a waiver of those.
Well, I may not have done a perfect job of explaining to her what I was inquiring about.
Nevertheless, we're here.
But, yeah, that was the reason why I came in. I do appreciate you guys letting me have the opportunity to talk to you anyway. I understand it's been an abnormal day.
Well, the way I read it, we would have to have a written application and a written reason of good cause for us to consider it.
Yes, sir.
I think that's step one. I think you're smart to come up here and explain why you want to do it, and then the commission would then have to vote on it once we receive that, which the earliest would be at the next commission meeting.
And the clock's ticking.
Well, that's the reason why, like I say, at this point, I'm getting to the point of not wanting to.
You got one more meeting, no, you got two more meetings to get it done, and then.
I've pretty well decided that there's not going to be a Friday deal that I can put together between now and June, so we're down to it. But yeah, that's fine. I can get that taken care of, submitted in writing, and then.
Where is the 30-hour course?
Yeah, the Friday deal, I just
explained in here.
It looks like to me this ought to be important enough that somewhere along the line, you just.
In the event, though, that you're under the understanding that you have a license, it's not really a point that you would review it.
Yeah, but you've known for a year you hadn't had one.
Well, yes, sir, but that's what I'm saying, is that for that year, what I've been doing is trying to find that 30-hour course to get it done. In other words, that it's not the main amount of my occupation, of my time, is not as an auctioneer.
Right.
Because of that. So that's where, now, I'm pursuing it getting to that point. And that's the point where in other words,
I understand.
I work in and around the business.
Right.
But that's your chart.
That's the point where it's important to have it. It is.
Bobby, another thing, the main focus of our business is municipalities.
Right. Exempt anyway.
Right.
I mean, I've known it too, but to be honest with you, it slips my mind too, because we're doing it every week, trying to take care of business.
Right.
And not thinking about human error.
I've got a question. Where does it say in here what our 30 hours has to be?
But specifically it has to be?
Yeah,
what is it? It's not in here what it has to be on, is it?
No, not that I know of.
Well, we approved all of the National Auctioneers Association's thing.
They're sure that there's 30 hours of that online.
Oh, I believe that there is.
I'm saying I don't understand why it wouldn't be eligible if it doesn't spell out. I know people give 30-hour courses where they go get them, but why couldn't he get 5 other 6 hours and mount to 30 hours? Is that possible?
I didn't get 5.
I said, what if he took 30 hours in segments online or something? Would they necessarily have to be just in a 30-hour deal?
Yeah, don't say it. Does it have to be 30 classroom hours or 30 hours in one pop? Could it be 5 here, 6 there, 4 there? Like you could have got 7 at the last TAA meeting.
I may have misunderstood. I read it to specify that 30-hour course, the 30-hour course that you do prior to licensure.
But
I think where Marvin's headed is if you can get 30 hours of education and submit that with your application.
I was actually going to offer that. If that's an acceptable solution, I don't have a problem with that.
I think Susan found something. If you can go to jackhammer.
In the statute, the licensing statute, for someone desiring to get a license as an auctioneer, it states that they've successfully completed, in addition to the education required by subdivision A2, which is for the apprentice, 30 hours or more, 30 hours, it says of more, rigorous classroom instruction in an auctioneering-related subject approved by the commission. So it does say classroom instruction.
That's what I thought.
So you went from a...
But you're saying
I'm still confused. That's from an apprentice to an auctioneer, right?
The statute says classroom instruction.
Yeah, but that's from an apprentice to an auctioneer.
Yeah, but as I understand it, with it being the re-educate, retest, and reapply, that's where that 30 hours, in other words, that would be basically the same process.
Yeah, the same process. Okay. I see now.
Well, I would be in favor if you can supply 30 hours of education.
Of regular CE type education?
That would suffice for me.
Yeah, because to me, that don't necessarily mean the same thing.
30 hours of what?
Just 30 hours of auctioneer education. I mean, doesn't have to be all in a classroom. He can do it online, and there's through the NAA and through other schools that they have 30 hours of auctioneer education.
Yeah, this is like starting over from an apprentice. This right here is.
Your rule does allow you, it says that you can waive reexamination and the additional education requirements. It does say, or in lieu thereof, impose such other reasonable conditions or requirements as it deems appropriate.
We have the authority to do that, Marvin, if you want to do it that way.
Well, I think the first thing he needs to apply.
Yeah, I know. I mean, he does, but that's going to be tougher to get done.
I think the reason why the point was that if I read that correctly, looking on that graph, and that would be the one that was printed out in the last newsletter as well, was that it specified 30 hours and 6 hours continuing education. That was the point where I assumed the two to be different. Well, I got 6 in February of last year. Right. But that was the point where I differentiated between 30 hours of instruction and continuing education.
Do you have an apprentice now?
Sir?
Do you have an apprentice now?
No, sir.
You have a full license?
Yes, sir.
Oh, that's what you had?
That's what I had. That's right.
Where does it say if he's got a full license, he's just late, that he has to take 30 hours?
That's the point where it went over 2 months.
That's on our chart. When it went over 1 year.
It's between 6 months and less than 2 years.
Rule, but your rule states that.
I think it actually begins after 2 months.
After 6 months.
After 6 months.
Oh, okay. Maybe
There's different periods outlined, but it comes from your rule,
Well, actually,
late
you're right, it
renewal
does
of
start.
That was
license.
after 2 months.
There's a 60-day grace period in which any auctioneer can renew late and just pay late fees.
Right.
After that 60 days, you've added in your rules, there's a graduating late penalty fee, and then 30 hours in retesting. Have to reapply, 30 hours in retesting. Up to 2 years, you said, all right, you got to reapply, I got to pay the higher fees, got to take the 30 hours and got to retest. But we do have the authority to waive the test and waive the education. You don't waive the fees, but you have in the past waived the 30 hours of testing.
Can you waive that, or should we wait until he puts in the application?
It does say upon written submission, so I think it would be best.
Yeah, we have to wait on that.
I mean,
We have a meeting
we've cut
next
some
month.
major slack here today, so we might as well stay on cutting. You know, and so,
We did.
you know, we sure did a while ago. In my opinion, we did. So I think that he ought to go ahead, if that's the requirement, submit the deal, and then let's vote on it next time around.
We do have a meeting in April.
Is that date already established? It'll be the first
Monday in April.
First Monday.
Okay.
April 1st. April Fool's Day. But you don't have to appear.
You don't have to appear, you just need to have submitted your materials by then.
You might mention in your letter, so to remind them that at your meeting, I spoke with you, and
We know if there's going to be a hearing before that meeting?
We don't think so, but we don't know.
You never know. Okay, well, we'll pursue that course of action now. And once again, I really appreciate y'all letting us do this. I know I wasn't on the agenda, and I thank you for the consideration.
You have anything else?
so
Entertain a motion to adjourn. All in favor, stand up.
Stand up. Hit the door.
Hey, can we take these on with us? Hey, turn this off.
just close it, let it power down.